Good morning, all. This hearing is in the matter of CFI 091-2023 and is being held by way of video conferencing before His Excellency Justice Lord Angus Glennie, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Al-Tamimi and Company. Lead counsel is Mr. Bobby Friedman. The defendant is represented by Emirates Legal, and lead counsel is Mr. Seb Oram. Thank you, Your Honour.
Thank you. So, Mr. Friedman, you're going first, is that right?
I believe so. Yes, yes.
I'm not sure what the tradition is in the UAE. There we are. If you're agreed, that's fine.
Yes, we are.
And we'll have about 2.5 hours between each.
Yes, so I'll go a bit shorter to allow time for reply. So I'll take whatever's left of my 2.5 hours afterwards.
Yep, and we'll need a break, a quarter of an hour in the middle of the morning.
Yes.
Hold on. It's okay. Someone else's laptop. Right. Yes. Ready when you are.
Very good. Thank you. Can I check that my note has made its way to you?
What note?
I think that's the answer, that it hasn't. We sent across earlier this morning a note to accompany the closing.
Right. Give me a second. I'll see whether it's. I'm reluctant to get out of this screen, but. I got a note of 3 cases to be added to the authorities bundle. I don't think I got any else.
So there was one that we sent across, and I did think we had a confirmation from the registry that it had been placed before you. But I think it would be good for that document for you to have that document, just because I could refer to it, and it will help shortcut.
Yeah. Hang on a second.
Justice Glennie, if this helps.
I've got it. How long is it? 24 pages.
Yeah.
Nothing's ever shorter than 24 pages in this case. Right. If you give me a second, it's easier if I print it rather than.
Yes.
Or you can. Are you going to be referring to other documents?
Well, I mean, I'll largely try and take from this, but I will go on occasion to the bundle, but not overly so.
Right. I'll just download this and work on a screen version.
I mean, would it be helpful for Your Excellency to have sort of 10 minutes just to skim it before we start, or I mean,
you know what's in it, and I don't.
Well, I hope it is helpful. I mean, I imagine that probably does make sense, but obviously having your hands as to what's better for you.
Yeah. Yes, give me 10 minutes to skim it then. I'm afraid this probably comes out of your 2.5 hours.
It's fine.
Yeah, well, you can stay online if you like. I'm just going to download this and then skim it.
Very good.
Mr. Oram, are you there? Yes, yeah. Yes, well, thank you. That was very useful.
Thank you.
Sorry, I've taken longer than you probably anticipated, but
no, not at all. But I think that should hopefully help me shortcut, because obviously the process of writing it down inevitably helps focus thoughts in any event. So yes, so Your Excellency, when I opened the case, you'll recall that I started by saying that this was a case about two competing narratives. Essentially, as BLS said, there was a right to terminate at 1 day's notice, that there were good faith and genuine negotiations starting on the 3rd of July, followed by a genuine change of heart, and a decision taken on genuine grounds to terminate my client's contracts. And in fact, we saw that massaged in the evidence by Mr. Sahu, suggesting that in fact they were always willing to take my clients back, and were hoping that we would do so even after they had informed the mission that there would be a change of subcontractor, so that it was all the way till the end. They were just desperate for us to perform. And they say everything happened quickly and in good faith. That's one narrative. The other one is my client's narrative, that the parties continued to contract, regardless of the renewal of the contract between BLS and Spain, and that although there might be a good faith negotiation about commercials, repeating a process seen time and again over the course of the contract, everyone conducted themselves on the basis that the contract continued for the new term. My client was required to spend time and money implementing this, but what in fact happened was, because BLS didn't like the fact that my client had made such a success of the CARES contract, and they wanted to appropriate the fruits of that for itself, there was then a preordained plan to remove my clients, where BLS did everything it could to try to cause a termination, made knowingly false statements to my clients and to others, conducted a sham negotiation, and tried to push out my client in any way possible. Now, of course, the court's heard a significant amount of evidence from both sides, and Your Excellency has seen what I've said on the witnesses in my note accompanying the closing, so I'm not proposing to repeat that, but I just emphasise that, having seen the witnesses and on analysis of their evidence, in my submission, the court can't be left in any doubt about what has happened here. You heard from Mr. Kamuni and Mr. McCow, who were open, accepted points against them, were engaged in a genuine recollection and honest discussion of what happened. They obviously feel strongly about what happened, unsurprisingly so, but we had two fundamentally and wholly truthful and helpful witnesses, and that is a very significant contrast to BLS's witnesses, in particular the four main witnesses. And in relation to those four, I don't shy away from the fact that I said they all turned up to give dishonest evidence. They did so. They conspired to do so to feed a false narrative to the court. And it was quite clear at points that they had been coached in their evidence, coming up with rote answers, clearly having points that they wanted to try and hit, giving answers that didn't respond to the questions that I asked them. And so when it comes to the analysis of what's happened, no reliance at all can be placed on what BLS's witnesses say, except where adverse to them, and that's a contrast to the evidence that was given by Mr. Kamuni and Mr. McCahow. So I want to just go through, in terms of what I'll say now, I think should hopefully track the structure of the issues that have to be decided. And the first issue is, well, what termination provisions applied? And that's why the question isn't what contract was in force, because it's common ground that there were ongoing contracts. The question is, well, what were the termination provisions? And so we put it in two ways. We say that the end point is that we say that the termination provisions remained the same as originally stated, until the expiry of the contract between BLS and Spain, or at least for the term of the renewed BLS Spain contract. Now, what my learned friend says, and as I explained in the closing note of paragraph 6, his defence says that there were contracts, but they were without any fixed term and at the will of the other. And so he would need to show that that was what was in fact agreed, that there was a quite significant change in relation to the termination provisions. Now, as I say, even if he's right about all that, as I'll get to on Article 272, it in fact would be a point against him, because it would only show that he would need to apply for a court order under Article 272. But in my submission, he's not right about that. Now, I dealt with the construction of the contracts in my skeleton argument. Does Your Excellency have that separately?
I do somewhere, yeah.
So,
Where do we do that?
I'm sorry?
What page, what paragraph?
So, sorry, give me one moment. So this starts, sorry, so this starts at 33. So 33 of my skeleton and onwards, and then I set out the reasons from paragraph 35.
Do you, sorry, just to be clear, you say that as from the end of the extended first Spanish contract, which was, I can't now remember the date, but
In February 2023.
February 23, you say from day one there was a new contract?
No, so my primary submission is a point of construction on the original MOUs, which is that what they are referring to, where they refer to the contract, they are referring to the contractual relationship between BLS and Spain.
Yeah.
So that for so long as BLS and Spain were, for so long as BLS was the contractor to Spain in relation to visa application services, then the contract was ongoing.
Yeah, no, I understand that was your primary case.
Yes.
But your secondary case, I think, was
Yes.
that when assuming that the original Spain BLS contract came to an end in February 2023, that nonetheless there was an implied contract which continued.
I mean, to be clear, I accept that the BLS Spain contract came to an end. That's common ground. I accept it was then renewed.
Let me rephrase my question. Assuming that not only this BLS Spain contract came to an end, but the contract between you and BLS terminated in accordance with the provisions.
Yes.
Then you say there was then an implied contract which continued and had to be terminated by application to the court, etc.
Yes, and it was, we say it was essentially, it was on the same terms, that it was renewed on the premise that the contracts between my client and BLS terminated automatically when the BLS Spain contract terminated automatically. There was then a new contract for the renewed term. Effectively,
when did that come into existence?
Well, there are two ways in which it could be said to come into existence. Either of them would do for me. So one is on the signing of the emergency contract, but I would say in any event from April the 13th, when the new contract was signed between BLS and Spain for then the long term.
So it came into existence on the signature of the new Spain BLS contract.
Well, it's on the signature of it and on the conduct of the parties by, in fact, immediately thereafter.
Well, when you say immediately, it's very sort of loose word. When do you say it?
Well, it would be. I mean, my primary case, it would be immediately upon the continuing operation on the signature of the new contract. But Day one. But even if I were wrong about that, so I do say that's enough, then in any event there was sufficient conduct, and this is what I set out at paragraph 9 of the closing.
Yeah.
From all of the steps that were taken, and we went through I went through them with the witnesses, and I've set out all of the
various
structure,
facts. Yeah.
set out the documents here. So you'll remember it was not just in relation to causing a complete change in the setup of the VAC in order to accommodate the national visa. It was the requirement to recruit new staff, to undertake training, to make changes in relation to the online systems, and then we saw, for example, the various other email changes I set out in the closing. The fact that all of these steps were taken. We also saw, and this is set out at subparagraph I of paragraph 9, that there was a requirement under the contract to notify Spain of the subcontractors, and it wasn't suggested that this was caveated in any way. And so the whole point was everyone just carried on, continued, indeed additional performance, and everyone performed their obligations. Now, if I might just pick up an authority on this, which is in does Your Excellency have the authorities bundle?
I can do, yeah. Which one is it?
This is at page 1574.
What I don't have is the system of just pressing on a button and bringing up the page. 1574.
Yes. Just to show you the case, the first page I'll go to is 1575. It's Dubai Court of Cassation case.
So is this the new ones that were sent to me over the weekend?
Yes.
Oh, I haven't got those downloaded. It would take me a bit of time to get them downloaded. Do you want me to? Why
yes,
just tell me what it says?
Well, just to pick it up for your note at 1575 of the authorities bundle, it relates to a scenario in that case where there were fixed term contracts for the provision of legal services. Then there was an expiry, the contract ended, and then what happened was that the appellants, the companies, continued to request consultations until the execution of a new agreement. That was what was said. But what actually happened was the court found, and this can be seen at 1578, if you'll note, going over into 1579, the court found that by continuing to make requests, as had been done under the prior fixed term, that then caused a new contract to come into existence for that period, for the ongoing period.
Yeah.
And page 1578, the third paragraph, I'll just read it out. It says this ground of appeal is unfounded, it is established that renewal of a contract, whether express or implied, may result from continued performance. The court has consistently held that for the conclusion or renewal of a contract, it is not necessary that offer and acceptance be contained in a single instrument. Acceptance may be manifested by any conduct which in the circumstances leaves no doubt as to consent. Such acceptance is not confined to signature of the agreement, but may equally be inferred from reliance thereupon and performance thereof. So that was a very similar situation where you had a contract for a period, it ended. There were a few cases that were then provided to the lawyer beyond the end date, and that was found to constitute the new ongoing long-term contract to be put in place. So it's very similar circumstance. It sets out that principle. And that's why when you say to me, well, what date was it? So yes, I do say it's from day one, but my submission, that's not that. I don't actually need to go into the specificity of that analysis because it's every step. It's the overall conduct, and we have all of that set out. And the other point to note is that the suggestion from a learned friend in his opening that it was terminable at will was not in fact adopted by his witnesses. His witnesses accepted that the termination provisions under the original MOUs continued to apply. Whether or not that was formally under the original MOUs or there had been a renewal doesn't matter. And that's what I set out at paragraph 7 of the closing.
Yeah.
Because his point, Mr. Sahu's own evidence, was the expectation was that there was the continuation of the relationship. That was how the parties proceeded. We saw in the KSA legal notice, the 19th of September notice, that specifically performance was required under the terms of the original MOUs. And Mr. Sahu accepted this, and he said that particular MOU is going on, that it's ongoing. And he accepted because that notice specifically referred back to the termination provisions that we say apply. And he said the terms in the MOU has to be followed. And he said the position at that time for BLS was that the termination provisions that applied were the termination provisions that we just saw in the original contract. So it was common ground between the witnesses that both sides proceeded on the basis that the original termination provisions still applied. So when we look at conduct, it was accepted by everyone that they conducted themselves on the basis that those termination provisions were in effect. So that's why, if I'm wrong, I've set out my points of construction. I do say I'm right about them, because for the reasons I've set out in the skeleton argument, the mischief that was being met was a circumstance in which BLS lost the contract with Spain. And it was obvious why in that scenario you had to end the contract with my client. There was no sense, and it wouldn't make sense, it would be commercially unreasonable to impose a cliff edge for both sides, would be detrimental to both sides potentially, and which would end up punishing a party if one of the others decided to walk away. So say I'm right as a matter of construction on the original contracts with my clients, but even if I'm wrong about that, it's absolutely clear there's an agreement with it between the parties that there was an ongoing contract. The only disagreement is as to whether there was an ability to terminate at will. But that's BLS's own witnesses disavowed that case, and all of the conduct makes that clear. How could my client be required to undertake very substantial investment under the national visa, under the renewed BLS Spain contract, unless unless the contract had carried on? So I say that that's why the same termination provisions apply.
Mm-hmm.
And this is something else where I also say that, to the extent relevant, if Your Excellency were to be against me, which I say you shouldn't be, but if you were to be, obviously this would be affected by documents, internal documents showing what was going on, and these are documents that haven't been provided.
So documents, internal documents which haven't been provided, which would have shown what?
So, well, I've set that out in my. I've obviously set out my
No,
list
on this particular point.
So it's at point 29.1. So, for example, all the correspondence with Spain, we haven't seen any of that, because that was correspondence where we say my client was nominated as the ongoing subcontractor without any caveat. Now, in fairness, Mr. Sahu didn't suggest that there was a caveat, but we would have seen the terms in which that was all put. We would see the internal terms in which my client was treated as the contractor on the ongoing basis.
Yeah.
So in my submission, it's absolutely clear. I mean, to put it another way, what else was going on? How were all of these requests made of my client? And the witnesses tried to suggest that somehow they didn't know about some of these requests. Obviously false evidence in circumstances where Ms. Curie requested photos of the amended VAC, where we saw that Ms. Curie was on various of the other chains, that Chenthu sent out one of the requests in relation to the national visa. So there was an attempt to try and dissent from that, but it was just, I mean, that was just an example of plainly incorrect evidence. And in these circumstances, what else was going on? And to add to that, not only did BLS's witnesses themselves disavow the suggestion of a termination at will, but it is also relevant to that it was also accepted by the BLS witnesses, and this is paragraph 8 of my closing, that there was a distinct difference between commercial negotiations and the sense that there would be a removal under the contract. Commercial negotiations had happened at various points throughout the relationship between the parties, and Mr. Sahu explained that when the factual circumstances changed, BLS would ask for more money. So you agree the operation on one basis, and then it transpires that actually there's a lot more people coming to get visas. BLS will come back and ask for more money. And that's part of the good faith obligation between the parties. That was Mr. McCamooney's evidence, where he explained that what he would do would be he would negotiate in good faith, because you're working in a long-term partnership. And if the numbers change, then you're willing to renegotiate, because if the volumes are a lot higher, that changes the overall financial position. So the fact that there was a discussion about commercials was just repeating what had happened in the past. But as I say, this ended up being accepted by BLS's witnesses. And so there is just no basis to the suggestion that there was an ability to terminate at will. But as I say, even if I were wrong about that, the only place it would get my learned friend is to Article 272 of the Civil Code, and that would require him to have applied to court, which he didn't do. So on any view, and I'll come to this now, on any view, on my learned friend's case, there was no express resolutory condition in the contract. So this is this then brings me to the provisions under the Civil Code. Now I addressed them in opening as well, but I'll just go to use some of the time. I just want to deal with a little bit with some of the authorities. And Your Excellency will recall, this is set out in my skeleton at paragraphs 28 and 29, where I set out the distinction between Article 271 and 272. And Article 271...
So this is paragraph what of your skeleton?
28 and 29.
Of your original skeleton?
Yes.
Yeah.
And essentially, under Article 271, there are two relevant aspects to ending a contract. One is about notice, and one is about termination itself. Article 271 says that the parties can expressly agree to dispense with those requirements. Article 272 applies in other cases where there's no express agreement, and you have the implied termination right, and then you go and get a court order. And what one needs is the express resolutory condition. As I explain my skeleton argument, that needs to be clear and unequivocal. I'll pick this up, if I may, in the authorities bundle.
Yeah.
Page 996.
Yeah.
So one can see this is.
Hold on a sec.
Sorry. Well, if you're having to scroll, I'd just go straight to 999.
No, I'm just trying to find. I've got an awful lot of different bundles open.
Yes.
Sorry. Give me a sec. Right, page what?
So 999.
999.
999.
999.
So this is the Dubai Court of Cassation case from 2021.
Yeah.
We can see nearish the bottom under legal framework for termination clauses.
Yes.
The established jurisprudence of this court provides that while the law does not require specific language for an express termination clause that deprives the trial court of all authority to assess grounds for contract rescission, such clause must be stated in clear and definitive language. The clause must indicate that contract rescission occurs inevitably and automatically upon mere occurrence of the triggering breach, without need for judicial ruling upon non-performance of the obligation. And it's that, in particular, not only does it have to be clear and definitive, but it has to specifically be clear and definitive about the fact that there is no need for a judicial ruling.
Yeah.
And just what, sorry.
No, Karen.
Just while we're here, if we go over to the page to the top of 1000, just to reiterate the point I made in opening, that under Article 272, you can always perform the obligation at any point. And an order can be made on any terms. And this is a case where obviously we've made absolutely clear that we will pay. The court just needs to tell us the amount. So if we can then go to page 11 of the authorities bundle.
11.
Yes, please. And this is Sanhuri. It's the commentary on the equivalent Egyptian civil code.
Yeah.
And if we see the go to the footnotes, please, at the bottom of the page.
Yeah.
And what else Sanhuri makes clear is that it's a need to ipso facto terminate. And the cases here where the court has made clear that Article 271 isn't engaged equivalent are stark. So we can see at clause 11, footnote 11, sorry. There was a termination clause in a sale contract stating if the balance of the price is not paid within the period specified, the sale shall be deemed void. So one would think that was in pretty stark terms. The sale shall be deemed void if the balance of the price isn't paid. But that was held merely to be a reiteration of the implicit termination clause and under Article 272. And we see a similar outcome at footnote 12. Again, didn't ipso facto terminate. In a settlement agreement, it was said if the purchaser breaches any term of the settlement, the sale shall be void. That doesn't have the meaning that was claimed because it was nothing but a reiteration of the implicit termination clause required. If there is a breach, the sale...
and therefore you have to go to the court to get some sort of declaration or order.
Yes, because it says it's nothing but a reiteration of the implicit termination clause. That is Article 272.
Yeah.
So you have to go to court and get the order.
Mm-hmm.
And I mentioned the point earlier about ousting the judicial consideration of it as being an important point. Now, a key indicator of that in my submission is that where there's an express resolutory condition, you would expect this to be capable of being determined without court intervention, without a determination by a judge. So, I mean, in fact, how difficult it is illustrated by the two examples in Al Sanhuri, because it does say that if the balance of the price is not paid within the period specified herein, but that was not enough. But one could imagine examples where something is a pure fact or not. So, for example, if a court makes an order to wind up a company, then the contract is terminated and there is no need for a court order. You could imagine that kind of phrasing. That'd be explicit in unequivocal. But what we have here is a contract which suggests that notice can be given for material breach. That isn't explicit and unequivocal in two separate ways. The firstly is it doesn't set out in a manner that doesn't require judicial intervention what breach counts, because materiality is a question that requires an evaluation, and naturally requires an exercise by the court of its discretion as to determine whether it's material or not. But secondly, here, it's not stated that there is no need for a court order. And while I accept that there might in theory be a case where it isn't said there is no need for a court order or there's no need to apply to court, such wording can easily be put into a contract. It wasn't here, and the wording here would be at best equivocal. And there's just another point to draw out, which is that insofar as any specificity is given at all, it's given in relation to notice requirements, where it sets out that where it's set out that notice needs to be given, 60 days notice needs to be given. But there are two separate requirements. One is notice and one is termination. If we just pick that up at Authorities Bundle 2.
Page 2.
Yes, please. And this is still in Al-Sanhuri.
Yeah.
And we can see the commentary. Serving notice, the second paragraph, serving notice to the debtor before seeking termination has a twofold importance. The judge will respond quicker to the request for termination. Judge will more likely order damages. Notably, the debtor does not have to be served notice before seeking termination if he's expressed in writing he doesn't wish to perform his obligation. And then over the page at 474, Al-Sanhuri deals with an order for termination. An action must be filed and an order made to terminate. So what point why I illustrate this is that it's very clear that termination and notice are two separate requirements. You have to comply with notice requirements, you have to comply with termination requirements. But the point here is that under the contracts, insofar as the termination clause provides any specificity about steps to be taken, it's in relation to notice. It's not about how one terminates. So it's saying that a written notice can be given, but that is dealing with the notice requirement. So it actually puts us at a yet further step removed. Not only does the wording in and of itself not meet the very high bar that has to be met for 271, but in any event, the wording is directed at notice, and there are separate requirements for notice and termination. And it's a deliberately high bar to meet, and it just wouldn't work in this case, because ultimately, how could it be said between the parties, well, you know, this is a material breach, this is something that requires court intervention? So bringing us back to where we are, if I'm right that the original termination provisions apply, they would either be under the original contracts or on the renewed contract, and or on my next fallback case, which is, well, on any event, these were ongoing contracts that weren't terminable at will. That's my learned friend's fallback, where he says there'd have to be reasonable notice. In any event, in relation to his terminable at will point, all of those do not have an express resolutory condition, so you'd have to go to court under Article 272. That means any breach could be cured, performance could always take place. It also means, and this is the crucial point that I drew out in opening, that the contracts are ongoing. And that is why my primary case is that we just get damages in lieu of specific performance. We're not in that English-Scottish case where the court is saying, was that termination valid? It's a question as to whether the court should terminate now, prospectively. And so that is, in my submission, where we end up. And the final point to note on this is that, as is accepted, I think, by the learned friend, under Article 272, it involves judicial discretion. And Your Excellency will recall that my learned friend in his counterclaim has applied for an order now under Article 272 in the alternative, saying, well, you should terminate now in any event. But of course, the court is exercising your discretion. The court has to look at the conduct of BLS. And that brings into account what I say is the dishonest participation of BLS in these proceedings and its perversion of the court process. So in any event, it's a further reason why we could never sensibly be in Article 272 territory, even if the allegations of breach were made out, which they are not.
Yeah. Are the sorry, just a mechanical question. Are the various articles relevant to this case? Are they all set out somewhere in one of the documents?
Yes, so they're in the authorities bundle.
Where?
So they are at tab 2, page 17, but also there's then the James Whelan commentary, which starts at page 137. Sorry, 1371.
Of tab 2?
No, sorry, that's tab 55.
1371.
Yes.
Thank you.
Now, I've also dealt with the point in my skeletal argument that actually under UAE law, onshore UAE law, there's no concept of a termination at will. It's a common law concept which doesn't apply. And if we just go to 1207 of the authorities bundle, please.
Yeah.
That's explained there by the Court of Cassation 253 of 2024, third paragraph, whereas this ground of challenge is unfounded, says if a contract is valid and binding, neither of the contracting parties may unilaterally rescind, amend, or terminate it, except with the consent of the other contracting party or pursuant to a provision of law. But the other point to bear in mind is that where there are some particular exceptions. This can be seen at page 300 of the bundle in relation to a contract of works, which is not said that this contract is. But where there can be termination at will under such a contract, this is in the middle of the page, about 9 lines down. It says, in balancing the interests of the employer with those of the contractor, the law obligates the employer who terminates the contract unilaterally to compensate the employer not only for the expenses incurred and the works performed, but also for the profits he would have realized had he completed the work. So Mr. Oram says, well, I have a 6-month, he says that he has a 6-month termination provision. Now, there are a number of arguments that show why that doesn't get him anywhere. The first is that we seek damages in lieu of specific performance. So he's trying to run a counterfactual case, but we are not in the counterfactual because, as a matter of fact, the contract has continued. So it just doesn't get him anywhere to say, well, I might have been entitled to do something else, because we're not in a counterfactual, we're in the real world. And in the real world, he hasn't sought to do that. The second point is he would still have needed to go to court and get a court order. He hasn't done that. We are now at that point, be prospective only, but he's not entitled to that court order. I have all the bad faith points, which I'll come to anyway. But in any event, the other answer to that is, even if he were right about that, then we would be entitled to be compensated for the remainder of the term. So it might mean that he would be allowed not to use us if we were such a contract, which I don't think it hasn't been suggested we are. But even if he were allowed not to use us, he'd still have to pay us. Still need to be compensated. So it's something else that it just doesn't get us anywhere. Doesn't get him anywhere. So that's what I wanted to say on the contractual terms and the mechanisms to be used.
Can I just ask you one thing?
Of course, yes.
Going back to the position in April or February or April 2023, let's assume that some of this may be controversial, some of it may be obviously wrong, but I just want to get an idea of how the contract works. Assume that at the end of the contracts attached to the first Spanish contract, in other words, the existing contract between the claimant and the defendant here, that's come to an end, assume. You say, but there's an implied contract to carry on because of what they did and that sort of thing. How would a person in the position of the defendants, if they wanted to not to lose the opportunity of continuing the contract with you, but being free to negotiate with others, how would that work?
Well, they could agree an express resolutory condition with us. So they could say we can. They could agree a fixed term. So they could agree a fixed term with us. My learned friend in his defence specifically says that there was not a fixed term. So that's why that's not an answer to him. But they could have said, we agree a contract with you for a fixed term that will expire automatically on 2 months. They could have done that, but they didn't. And as I say, it's common ground that there was no fixed term. So that would be one way in which they could do that. I mean, they could also for breach have put in place an express resolutory condition for breach, saying,
I'm not thinking about breach for the moment.
Right. Okay. Yeah.
Take a case where could they have a contract with you, which basically was expressed to last until the conclusion of negotiations with you and other parties, until those negotiations have reached a conclusion.
Well, I mean, I query whether that is possible on the basis it's insufficiently certain.
Well, the reach a conclusion, you can make that more or less certain as you want to. You can say, and until we either sign a contract with you or with other parties. That's sufficiently certain, isn't it?
Well, it would be whether under Article 267, it could be explicitly. I'm not sure I agree it is certain enough, because it would need to be pending a certain event, and to say that the conclusion is something that is necessarily uncertain. When does it come to an end?
I mean, that would be your answer to that point.
Well,
the uncertainty.
But my bigger answer to that is that would be a fixed term.
How do you mean?
It would be a fixed term. It would be fixed because it would be fixed for if Your Excellency were right about that. I said I don't agree with, but if that were right, it would be a fixed period.
Yeah.
And the point is, my learned friend has specifically pleaded that it wasn't. There was no fixed term.
Well, leave aside what he's pleaded or not at the moment. I'll look at that when he makes submissions. But if the construction of that was that it was a fixed term, then it would work, wouldn't it?
Well, as I say, I don't accept that that would work because it's insufficiently certain. It would have to be into a specified event, and that isn't a specified event. That would be an evaluative decision.
And until we stop negotiating with you or with other, or stop negotiating with other parties.
But it has to be an objectively referable event.
What's unreferable about that?
Because to say, well, when we stop negotiating with you, it's self-serving. It pulls you up by your own bootstraps. It would have to be sufficiently certain to be for a fixed event. So it might say for 1 year. It might say until the expiry of this specific contract. So I see the point that, for example, it could be said in the period. Sorry.
The reason I ask this, I don't quite see putting some commercial sense into it. If they want to explore the market for other contractors, I don't quite see how they go about it.
Well, the answer is that they would agree. They could agree a fixed term. But this is just I think it's a difficulty for us as common law lawyers dealing with onshore UAE law, where we expect as a common law lawyer to be able to terminate at will. That's not how it works under UAE law. There needs to be breach, or there needs to be a fixed term. So they could have agreed 3 months, for example.
Yeah.
I see that in the period where there was the emergency contract, between the emergency contract and then the properly renewed contract, I could see how it could be said that there was that it was for the fixed term of the emergency contract, but not thereafter. But I do emphasise. I know Your Excellency said, well, pleading sort of deal with that, Mr. Oram. I've set this out at paragraph 6 of my closing note.
Yeah.
BLS says this is an admission on the defence.
What paragraph out of the defence?
Paragraph 42, trial bundle 135.
Okay, just. Trial bundle 135. Sorry, too many documents on one screen. 42, 135.
Yes, 5th line, but we start at line 3. The parties agreed to continue to perform the services and obligations as they'd previously done under the Spanish contracts without any fixed term.
I see.
So that's why we haven't prepared on the basis that we're having to meet a fixed term argument, because it's specifically said that there's no fixed term. I do say that's just an answer on that point. That's not BLS's case.
Yeah.
So that brings me on to, well, was there a breach? I dealt with some of this in opening. I've set this out in the closing note. I'm just going to sort of try and hit some of the points as I go through, if I may.
Yeah.
So points on this. It's clearly set out that there's a notice requirement in relation to material breaches, and where curable, you have 60 days. Only the non-payment breach is pleaded to be material.
Yeah.
For Ghana and Lebanon, no other breaches are pleaded. For Iran, the other pleaded breach is the data breach. And then for Saudi, we have the 3 breaches pleaded, which are misuse of the appointment system, conflicts of interest, and misreporting of the service fees. So those are the ones that we have to consider. And I'm not going to spend time on matters that weren't pleaded. Now, the position we're in is that I've referred to this in the closing note. It's a document that's at 3771 of the trial bundle. Which is.
Do you want me to go to it?
Yes, just briefly. This is
3771.
You'll recall it's Mr. Kamuni's email talking about progress being made locally. I hope to be in a good position to update you about payments. And
yeah,
Your Excellency will also recall both the response to the KSA legal notice saying, give us a reissued invoice, and saying, can we meet to discuss this so we can sort the invoices? And also the evidence of Mr. Kamuni, which was that he was discussing this with BLS and saying that he wanted to pay, but raising the issue of the fact that they were about to terminate him. So as a matter of fact, the only cause of this was the fact that there was already a decision to terminate.
Yeah.
So, I mean, we go through them in relation to Ghana. I mean, that's unanswerable. It's as I took Your Excellency to an opening. It's accepted on my learned friend's pleading that there was no basis for the overcharge, because he accepts the financials were the same under what he calls his renewed contract as under the original contract. So on any view, there was no basis to charge the overcharge. And in Ghana, the amount of the overcharge is bigger than the amount that was said to be owing. In fact, it's still said to be owing. So for Ghana, there just was no breach at all on any view.
Mm-hmm.
Then in relation to in relation to the other breaches, the other alleged breaches, again, I've set this out in the closing note at paragraph 12 in relation to the failure to pay. And again, what came out from the evidence was that this suggestion that somehow there was a big issue in relation to late payment was just another construct that was part and parcel of BLS, as we saw with all of these allegations of breach, of them all being manufactured. We saw the document. I don't think we need to go there. The trial bundle 3075, which was the description of the meeting in September 2022, which BLS had tried to suggest beforehand was all about failure to pay. About failure to pay on time. Mr. Anand accepted that actually what was being discussed at that meeting was that BLS wanted to go back from the 60-day timeline that was being allowed in Lebanon and Iran because of the banking system collapse and sanctions, that they wanted to move from 60 to 30. This wasn't a complaint about general non-payment. It was saying, we don't want to have 60 days anymore. That was Mr. Anand's evidence.
Yeah.
And Mr. Anand accepted that document, and as that document showed, there was no issue with Saudi. So the idea that somehow there was this ongoing problem was just wrong. I went at length through our reworked version of the aging report from Mr. Gupta. It was quite clear that that aging report was set up to try to make things look bad. It was accepted, of course, that and Mr. Gupta's evidence in his witness statement was that it was approximately 30 days. But put that to one side for a minute. That was accepted, and then Mr. Gupta prepares this aging report that just shows something completely different, an obviously unhelpful document. On that basis, he also frankly accepted in his evidence that it didn't include all of the other relevant factors over time. For example, that it was agreed that the payments during COVID would be delayed for obvious purposes, and of course the contract provides specifically that where payments can't be made as a result of matters outside of my client's control, then that's not a breach. So all of that, relying on all of these points, was just not good. I took Mr. Gupta through it. He accepted that the relevant date was the date of the final invoice, and he tried to suggest, well, there was just maybe one occasion where the final invoice was late. But our reworked table, and as the examples I took him to, shows that in fact those dates were very substantial, and if his case were right, then we were in breach for not paying invoices prior to those invoices in fact being issued, which shows the absurdity of it. And of course, you have to take into account when we in fact made payment. So all of that had to be taken into account. There was also this point which was reflected in the note at 3075 of the trial bundle, that it was agreed in that September that the two invoices would be paid at the end of month, i.e., the invoice from the 15th of the month would not become payable, would be dealt with along with the one at the end of the month. So we reworked the table on that basis, and what that shows is that actually there weren't worsening delays. In fact, some of the payments were made early. Some of them were made perhaps a day late, a few days late, if you took a strict 30-day timescale. Well, as I set out in the closing note, what was agreed was approximately 30 days. And more generally, we saw this from the cross-examination of Mr. Gupta, where when one actually forensically went through the only WhatsApps that he relied on and looked at the email chain, what we actually saw was just it's the kind of thing where I'm working with a solicitor and my clerk sends them an email and says, do you have an update on payment? This is not me saying they're in breach of contract and going to terminate because of it. It's just how when you have an ongoing relationship between parties, you inquire what the position is. Mr. Gupta accepted that it was just a normal back and forth. This was not a alarm bells, what on earth is happening relationship. And Your Excellency will recall, and I set out in my closing note, that we saw in relation to the period which he said had really terrible delays. In fact, he didn't email Ms. Taleb at all, my client's group accountant. So again, this is all just manufactured, and it was reflected in the excellent collaboration description used by Mr. Sahu and ultimately accepted by the other witnesses, which was if there were a material problem with payment timings, that couldn't possibly be said. And ultimately, if there were such problems, it would have been open to BLS to serve a notice in relation to that. But of course, BLS never did so. So there's just nothing in those complaints. But regardless, these are not material breaches. It doesn't go to the heart of the contracts. It's just a short delay in payment. And of course, these are obviously curable. And we saw in cross-examination that the purported termination letter itself conceded that such breaches were curable, but then said, well, you've taken more than 7 days. The contract says 60 days. But the principle of whether they were curable or not is agreed between the parties on the correspondence that they were curable. And it obviously was curable because the answer would be, well, you have to pay and then you cure it. If it said, well, you are in, I don't accept that this was a separate breach or that there was any such breach, but there was a persistent late payment, the answer to that would be, well, then you'd just pay on time, you'd cure it. So this is all just another manufactured basis that actually on analysis was just wrong, but in any event not material. No, apart from Saudi, no notice at all, and in Saudi defective notice because 7 days given. And of course we are in Article 272 territory, so, and we've said we will make payment. But that's on that. On the Iran data breach, I've set this out at para 14 of the closing.
Yeah, I have it.
And you'll recall from the cross-examination, it was all settled. It's right, of course, it's right that BLS was concerned about it. I don't dissent from that. When it first found out about it, it understandably wanted to know what was going on. But then specific inquiries were made, specific actions were taken, and that was settled. So on any event, this had already been, it is not alleged to be material, even if it were, it had been dealt with and therefore cured. And we saw ultimately that there was no discussion about termination on the basis of the Iran contract until the 28th of September. And this is at point J of paragraph 14, where Mr. Sy says, I feel this is strong enough to take action. That showed what was going on. So bad was this that Mr. Sahu started lying and saying that at this point he was thinking of keep carrying on with my clients and was maybe just going to impose a penalty under the contract with them. It was absolutely absurd evidence. He'd already informed the mission of the change in subcontractor. But I mean, but that in and of itself would show that this was not that serious a breach, if that were really true. But the point is, it was put to one side, and it was only picked up again when they were looking for ulterior reasons to try to justify this on the 28th of September, after the missions had been informed and while the purported termination letter was being drafted. I also dealt with in opening the terms of the contracts, and as I took Your Excellency through then, given the time I won't go back there, it was in my opening, that specific provision is made in the annexures to the contract, essentially saying we need to terminate someone if they get it wrong in relation to data breach, and we need to train staff. And we did terminate that person, and there's no suggestion that our training was inadequate. So if one actually, so there wasn't a breach at all. And Mr. McCahow said this in his evidence. He's basically saying, well, look, you run these operations for years and years. You have huge numbers of staff. The idea that you would be entitled to terminate because one member of staff does something wrong is just obviously unreal. So that only affects the Iran contract, but in any way, nothing in that either. Then we had these 3 additional assertions in relation to Saudi contract. Now, my submission, all of this is just manufactured. We had the walk-in slots where Ms. Kurian accepted that there was probably nothing in the complaint because she saw the emails which showed that this was approved by the mission and BLS. Of course, Ms. Kurian, giving evidence in the manner that she did, was unwilling to in fact accept that it was a complete answer and said, well, what about later? But she went 95% of the way to accepting it, and that was obviously right. And then I took Ms. Kurian through all of the correspondence, which showed that in relation to walk-in appointments, what actually happened was my clients were urging BLS to put in place the solution, and BLS refused. What we then saw was BLS used the issue in the very same period to try to create an excuse for termination through the WhatsApps with Layal, the infamous 29th of July WhatsApps, where Miss Curian refused to accept the mystery shopping exercise was going on the 29th of July, even though that was the date of the WhatsApps. So what actually happened?
I briefly forgotten what the mystery shopping was.
So do you remember the long series of WhatsApps where Leal, where there were messages with Leal, where they were asked to provide appointments on the next day? Do you remember this is the part where Miss Curian wouldn't accept that it was the 29th of July?
Yes, what did the mystery shopping refer to?
The mystery shopper was someone going to Leal and trying to book appointments for the next day.
Oh, yes. Okay. Yeah, I remember now.
And so the point being that at the same time that the mission is saying you need to introduce prepaid appointments, we are going to BLS and saying you need to introduce prepaid appointments. BLS, which has the contractual responsibility to do this, doesn't do it. It sits on its hands and then only introduces it after it's terminated us. They are then using that period of time to try to collect evidence in relation to this issue to try to terminate us. I mean, this is extraordinary bad faith behaviour. But in any event, it shows there's absolutely nothing in the complaint. I then deal with this at paragraph 15B and C, page 10 of my closing. The other two assertions were based on a document that Miss Curian said in evidence was prepared by Mr. Varsi. She was at pains to say it wasn't prepared contemporaneously, but only after the event. So it's prepared to be produced in this litigation. And in relation to these other two requirements, that there were staff conflicts and that there were discounted prices, we were just given no information. For staff conflicts, they don't even say who the staff member was or specify the relationship, let alone is there a single document or any piece of evidence. Likewise, in relation to discounted prices, completely unevidenced, no specifics given. And as I took the witnesses to and showed in cross-examination, BLS itself has made clear in response to the disclosure request that there are no documents. So on this, we have no underlying documents at all. So this is just a complete assertion, and there's nothing to it at all. Mr. Tiara,
would it be convenient to have a short break now, or do you want to move on to something else?
Well, I may move on. I mean, I think we've only been
an hour and a half.
Yes, albeit I think I only started, just thinking of the transcriber, I only started talking an hour and 10 minutes ago. So I appreciate it comes out of my time, but just for them, I may.
But I give it, if you want to give it another 5-10 minutes.
Yes.
You can.
Okay, I'm just going to try and rattle through this. So the point is, therefore, that.
Sorry, just to be clear, I'm not saying you've got to finish your submissions at that time. I'm just talking about the break for the transcribers.
No, I understand that. I'm just aware that I probably want to leave myself half an hour for reply. So in reality, I've not. I think I probably will. I may go till 1:45 and then hand over after the break to Mr. Oram if that works.
Right.
So on bad faith, we set this out at paragraph 16. There was the obvious point that that BLS wanted Saudi for itself. The witnesses turned up en masse to say no plan in July. We didn't even think about it until September. All of it was just utterly unsatisfactory. The 9th of June email of my submission speaks for itself. It didn't mean remotely what any of the witnesses said that it did. Of course, it didn't. The wording of that email just doesn't tally with any of that.
Where do I find that email?
1572 of the supplemental. I mean, I went through it with the witnesses, but the complete case of Access ensure recovery of the complete operation by BLS. It's obvious what it's talking about. They're searching around for how to terminate for any excuse. That's what's clause 2. They're deliberately ensuring that this will be done in secret. That's point 3.
Oh, that one, yeah, sorry. Okay. Yeah.
point 4. The whole point is this is a litigation or arbitration advice. It's not about the meaning of the contract, and the relevant lawyer wouldn't have opined on this if this was just about trying to boost the contracts. None of it works for all of the reasons that are set out in cross-examination. Mr. Tiara being copied to this, a man who claimed that up till the end of September he worked only on the DMC, had no reason to deal with my clients at all, had nothing to do with them. Yet in June, he specifically copied onto an email that's about getting rid of my clients. And then as the termination is happening in late September, Ms. Curian goes to the trouble of finding this email and responding to this very chain. So it's obvious that there was this predetermined decision. I've set out my closing note, and I won't go through it, the points in relation to each territory. In Saudi, we see this happening from April onwards. Mr. Tiara's evidence, I mean, he effectively ended up sort of giving up when it was shown to him, for example, that one of the staff contracts specifically referred to the Spanish embassy. He just went into effectively bare denials. There's nothing that could be said in relation to this. It was so obvious what was happening. In Lebanon, we have a 21st of July contract, all of the prior communications withheld. And Mr. Sahu himself accepted when you had a new contractor, there was a whole long process that needed to be gone through. Paragraph 22A of my note. Now, in Ghana and Iran, the evidence given by BLS's witnesses was dishonest, obviously false, suggesting that nothing happened until much later. For these, we have been completely starved of the documents, though it's clear that documents pre-existed and the communications we've been given. Again, I went through it in cross-examination. It was all of the evidence in relation to the 3rd July email was just absolutely ridiculous from Mr. Sahu. The idea that we failed to reply in time, saying that there was this tight deadline from the ministry, even though there's no evidence of that. The suggestion that we were adamant in not improving the commercials. Mr. Sahu ended up accepting that we were keen to renegotiate terms. Mr. Anam suggesting we never responded with any proposal for the updated points set out in Mr. Sahu's email. Again, just obviously absurd. Just clearly false evidence designed to try to excuse what was happening here, that it was a plainly sham negotiation. And we saw this, Mr. Sahu's evidence, probably there were a lot of low points in Mr. Sahu's evidence, but this really was perhaps the nadir. This point about, did you get quotes? Which when he said that my client's commercial proposal was nowhere close to the other ones. These were quotes that he refused to provide, refused to name who they were from. He started off by saying he didn't get quotes and he just got expressions of interest. He then changed his evidence and said by the 7th of July, he had got quotes because he was sort of so aghast at the figure that we provided. None of that, of course, ever brought up before. And all completely implausible and all completely contradictory of his evidence where he said he wasn't even thinking of replacing my client in July 2023. And all of this point about getting these 3 quotes just obviously didn't work. Ms. Curian said, well, we don't have a tender process. Yet the premise of Mr. Sahu's evidence was that somehow there was this formal 3-person tender process. And then we have all of the other aspects of it. Ms. Curian accepted that they locked our staff out. They refused to allow one of the members of staff from access to the system. She accepted that they locked us out from providing appointments. Ms. Curian tried to say that the other problems with the system were not part of this attempt to lock us out. I mean, that was other implausible evidence. Everything started on the same day. The problem kept getting worse, and day by day, more issues arose. And yet she suggests that somehow there was just some system upgrade. And of course, got no documents on the system upgrade. She didn't chase, didn't do any of the things that you would do if there was some long-running upgrade that was causing problems for the partner. And then we also saw I've set out in paragraph 27 the non-exhaustive list of all the ways in which there were deliberate attempts to harm my client, and it was exemplified as well by the hostile takeover, where BLS caused chaos in order to try and harm my client. Same with the prepaid appointment system, deliberately causing harm, deliberately hurting the relationship with Spain in order to further its position. And the simple point is that if BLS hadn't acted in bad faith, then there's no way that these contracts could have been terminated for a number of reasons. Firstly, these were rights that were exercised in bad faith, and they just can't do that. Secondly, if they were acting in good faith, they would have agreed new commercials. Thirdly, it was because they were in bad faith taking all of these actions that my clients were unwilling to make payments for a time and wanted to meet to sort it out. So that directly followed from where they were. Now that just brings me on to the non-compete.
Yeah.
I mean, it largely speaks for itself. As I set out in my closing note, BLS now accepts that it was the same business in Saudi. That was Mr. Tiara's evidence. But in any event, as set out in opening, it doesn't have to be the same business. The clause is much more broadly worded than that. The only other points are these, that BLS tries to say the clause doesn't survive. Well, the contract says it does. Clause 6 specifically refers to the term of the contract and 2 years afterwards. And clause 18 specifically makes clear that the non-compete clause survives. Now, there's one of the cases in the bundle, and this is a new case, so I won't spend time on it, but it's at page 1567 for your note. That sets out the legal principles. And it draws a distinction between a clause that lacks.
Is this a English case?
No, it's a Court of Cassation case.
Yeah, all right.
And so this just makes clear the point that there's a distinction between those clauses that fall with the provisions that when the contract terminates and those that survive. And it couldn't have been made more explicit that both the clause itself and the survivorship provision of the contract both make clear that it survives. I dealt in opening with this point about saying this is so broad that where there wasn't where my client was replaced with another subcontractor, the clause kind of proves too much. As I set out in opening, that's no answer for Saudi, but in any event, given there was a good faith negotiation obligation, that's a bad point. The final point is one that I haven't emphasised before, which I set out in the closing, and that's
what paragraph?
That's at paragraph 32.
Yeah.
Which is that the contemporaneous letters confirm that BLS, in fact, even in those territories, Lebanon and Ghana and Iran, was taking on some of the work for itself in any event. I know that Your Excellency wished to be addressed on quantum.
Yes.
So, I mean, really, there are only 2 points of quantum. I've set it out in my closing. Mr. Thomas's evidence was very poor indeed. Came across as an advocate.
You don't need to go through that bit.
Okay,
I'm more interested in the substance.
Yeah, and just say I've noticed a typo at paragraph 33 of my note. When I refer it's obviously he was an advocate for BLS, not for the claimants. So on the substance, 2 points really. So it was accepted by everyone that the revenue figures, in terms of the overall revenue figures, were accurate. because the DAR was accurate.
Yeah.
It was accepted by everyone that the BLS bills were accurate. There's no problem with the discount rate or WACC or any of that. So the only possible complaint, I'll come to the point about the use of different entities in a moment, but subject to that, the only possible complaint was about my client's costs. And I went through this in cross-examination with Mr. Thomas, and really, given the time, I won't go there. But it's set out in Mr. Girard's expert report at page 1185 of the bundle onwards, where he goes through and he correlates the profit and loss to the DAR. He then compares the profit and loss to the monthly payrolls. He analyzes specific transfers that were made. In Iran, he reconciles the Excel file provided with the profit and loss and then uses sampling. And then in Ghana, he obtains proof of payment for everything. So it's really just a case of reading what Mr. Girard says in this section down to page 1187, because he corroborates all of the profit, all of the costs. We also had evidence from Mr. McCall.
So you say 1187. Where's that in your note?
Sorry, I haven't put the reference to this in my note. So this is pages 118. Sorry, it's 1185 of the expert report.
And this ties in with your paragraph 34, does it?
Yes.
Yeah.
Yes, that's 34. Thank you.
Yeah. Yeah.
And it's essentially what Mr. Girard says. But in any event, no alternative been put before the court. So in circumstances where it said, well, we think these might be a bit high, well, if that were the answer, if that were right, then the answer would be to just provide the alternatives. Mr. Gupta claimed that he was Googling them. So where are they? What we've seen BLS do is instead just try to put a roadblock by saying, well, we just can't calculate anything at all. That can't be right. And then the other point then is a point about, well, were the profits passed on? Are they Access's loss? And I have to say, this is, I mean, we don't spend an awfully long time on this, and it's really quite desperate stuff. My submission.
Well, leave aside whether it's desperate or not. Tell me what the argument is.
Well, the reasons for this are, firstly, you have Mr. McCall's evidence. Have to be a finding that Mr. McCall is misleading the court. He explained clearly that so just to be clear, this doesn't affect ProX or Lebanon. Unaffected by this. The next category is Saudi, where High Skies was used. And as Mr. McCall explained, apart from a tiny fixed fee, all of the profits were passed on to Access. And he explained that it was put in place for tax purposes and because you needed a local entity for formal Saudi legal requirements. I've set this out at paragraph 35. Now, the only basis that my learned friend had for even going there was he referred to the contract with High Skies at 1280. We can see it at 1288 of the bundle.
Yeah.
Box 13. Skyworld shall settle all Access Group invoices within 30 days. Fees of 1% of the revenue. Now, Mr. McCall's evidence was that this just didn't represent the arrangement at all. But regardless, it was stated as a fact by Mr. Oram to Mr. McCall that this contract in fact provided for High Skies to take 99% of the revenue. It doesn't seem clear that that's right, because the way it's worded says for fees of 1%. It doesn't say for whom. But one really doesn't have to go there, because the point is Access did in fact receive all of the monies. Mr. McCall explained that, but also Mr. Girard explained that. And that is at 1188 of the trial bundle in his report.
So I look up another reference you gave me was to the High Skies Agreement.
Yes.
What page is that?
Sorry, that was at
that 1288.
Sorry, I've just lost that. Yeah, that was from the supplemental bundle. Sorry, I'm sorry. I've just managed to lose that as I was going through. Can I come back to that in 1 second? I'll just pick that up in my note. Yes, sorry, that's trial. It was 1288 of the trial bundle at box 13. Sorry, 1288 of the supplemental bundle at box 13.
Give me a second. Yeah. Okay. Thank you.
Thanks. So, but the fundamental point is it's not really about that. It's a factual point. All of the monies, over 99% were paid to Access. Mr. McCall gave that evidence, and that's confirmed by Mr. Girard. He sets out in his report from page 1188, dealing with Saudi. And there are 2 points that confirm this. There are audited financial statements that therefore show these cash flows coming into Access. And the only way to gainsay that would be to say, well, the auditor effectively has misrepresented the position. And as Mr. Thomas eventually accepted, that would be completely improper. It has been audited. It's found the money has gone into Access. But the second point shows this is right, is that obviously, if it's really being suggested, that's why I said pretty desperate, really being suggested that only 1% of the money went to Access. Access had paid millions of dollars to BLS. How did it do that if in fact it only got 1% of the money? The audited financial statements show that being paid. There's no dispute that Access paid it. So that obviously shows that the monies go into Access. Now, for Ghana and Iran, it's a different position. There's no High Skies issue. The only point here is that Mr. McCarr and Mr. Kamuni, as they explained, for regulatory purposes, formally have a local entity, i.e. one Ghanaian and one Iranian company there, both of them wholly owned by them. So again, for them, we have audited financial statements, but the difference compared to KSA is that some of the monies were taken out in cash and so are not shown on the audited financial statements. This is dealt with from 1189 by Mr. Girard, and the cash receipts are all authenticated. And again, this was explained very clearly in the evidence that all of the money was Access's money. But there's a further answer on this point, which just hasn't been seen by BLS, which is that even if it were right that those monies, in fact, were directed to be paid to Mr. Kamuni and Mr. McCall, and as such never reached Access, that's completely irrelevant, because the point is Access is entitled to all of these sums. It has an entitlement to it. There's no arrangement that entitles the local Iranian or Ghanaian entities to anything. And again, this was made very clear by Mr. McCart in his evidence. So, as I said, this is really, in my submission, the last vestige of the dam, just trying to pick holes and suggesting that Access didn't get this money when it obviously did. And so those were the only points on quantum. Otherwise, the figure should stand. In terms of interest, we've added to the bundle at 1573 a case confirming that
So
obviously
which bundle?
Authorities bundle. You won't have this downloaded, I believe.
Right.
Just saying that should be 5%.
What is it? Sorry, what does it show?
Interest should be 5% when it's a commercial rate.
From when?
1573. But of course, under Dubai law, the maximum is 9%. So that's a separate point, because obviously the 18% that attempted to be charged with was that. So look, I've had to slightly rush through a site for entirely understandable reasons. Didn't have some of that time. I would retain time for a reply. But put simply, we say the case has manifestly been made out on the facts. We're right as a matter of contract. In any event, we are right as a matter of bad faith, which is effectively a trump card. My own friend, there's no breach, there's no material breach, there was no notice. In any event, he'd have had to have gone to court for an order. He didn't. He wouldn't get the order now. Regardless, we have bad faith. And then we have a straightforward case on quantum. And finally, we have the non-compete, which is largely unaffected by anything that sort of happened beyond the points that I've set out in my closing. And then finally, we obviously have the point about adverse inferences. I've set out the detailed adverse inferences in the closing notes, at paragraph 28 onwards.
Yeah. Thank you very much.
Thank you.
What I suggest we do is stop for a quarter of an hour now for the transcribers. And then I don't know how long you want to be before we break again, but we can decide, we can see how we go. So we'll resume in a quarter of an hour, which is quarter past 11 UK time. Thank you. Yes, Mr. Oram, are we ready to go?
Yes, Your Honour. I will structure my submissions under 3 parts. In the first part, I'm going to look at what were the terms that the parties were proceeding under by the time we get to October 2023. And my submission is that by that stage, they were proceeding under ad hoc contracts, i.e. contracts with no fixed term. My alternative submission, but not one that I advance with any great force, is that there was a contract that was terminable on reasonable notice. In the second part of my submissions, I will look at whether or not termination was effective by virtue of the letters that were sent on the 1st of October 2023 in respect of the Spanish subcontracts.
Give me that date again.
1st of October 2023. And 11th of October 2023 in respect of the Cyprus contracts. And Your Honour, in relation to that, my submissions are, first, that the parties had embarked on new negotiation in July 2023. Once that fell apart, there was no need for termination. The contract would come to an end simply because that was the effect of not reaching agreement. Under that analysis, good faith and abuse of rights is not relevant because no right was being exercised. Secondly, in any event, the existing ad hoc contracts were validly terminated by those letters because the payment under the subcontracts was late and the notified default had become incurable. And thirdly, the defendant was not acting in bad faith. In the final part, I will look at remedies. And my primary submission is that the claimants have not suffered any more than nominal damages on the evidence. And I'll address remedies more generally in respect of the claim and counterclaim. I turn then to part 1, which is to start to look at what were the terms on which the parties were acting by the time we get to October 2023. The first limb of my submissions is that each of the Spanish contracts expired without court order on the 25th of February 2023. So that is by effect of the effluxion of time provision. Although we've seen it a number of times, it may be worthwhile just going to that again. It's at page 2300
of the main bundle.
Of the main bundle. This is taking, for example, the Saudi Arabia contract, and the relevant clause is at 2302.
Hold on. Two, 300.
Yes, that's the front page. And then I'm going to 2302, which is the clause 7. So Your Honour, the first sentence of that is that this MOU shall come into force from the date of its execution and shall remain in force till. So it is an expiry provision. In other words, once that condition is satisfied, this contract will naturally come to an end. The key wording is till the subsistence of the contract awarded by the Ministry of Foreign Affairs. And that, in my submission, means the contract that had been awarded in December 2016. It can have no other meaning. It does not mean, as my learned friend submits, the existence of a contractual relationship between BLS and the claimants on similar terms to the ministry contracts continuing to subsist. I take that from the claimant's reply at paragraphs 29 and 33. That's the battle line in respect to this argument of construction.
Yeah.
And I will go briefly through the principles of interpretation under UAE law. Looking at the authorities bundle, one starts at page 1461.
1461.
Yes. Article 257 sets out the basic principle. That is, the basic principle in contracts is the consent of the contracting parties and that which they have obligated themselves to the contract. 2582, which is on the same page. The basic principle.
I'm sorry, you're going too fast.
Sorry, Your Honour.
I'm still trying to get the right page.
Sorry.
What page is that?
It's 1461 in the authorities bundle.
Right, sorry.
That's all right. 257 identifies the basic principle, which is to identify, naturally enough, what the parties have agreed. The basic principle in contracts is the consent of the contracting parties and that which they have obligated themselves to the contract. 258 then sets out how that is established, and 2582 sets out the basic principle or presumption is that words have their true meaning and a word may not be construed figuratively unless it is impossible to give it its true meaning. And then 265, which is at page 1464, if the wording of a contract is clear, it may not be departed from by way of interpretation to ascertain the intention of the parties. And finally, 2661 on the same page, a doubt shall be interpreted in favour of the obligor. So those are the principles by which one interprets the words till the subsistence of the contract awarded by the Ministry of Foreign Affairs. It unequivocally in my submission points to the conclusion that it means the contract award that had already taken place by the time that those contracts were entered into. And I'll deal at this stage with the point that my learned friend took in opening about the defendant's case being an opportunistic one, in the sense that I accept that by the time a later contract comes into being by conduct, I accept that all the terms are the same, except that there is a fixed term. But that isn't in my submission by reason of any opportunism. It's because the meaning of these words don't change. If in December 2016, the contract awarded means the contract awarded in December 2016, that meaning remains the same in February 2023 when a contract is formed by conduct. It doesn't change its meaning to mean a newly awarded contract that hasn't yet been awarded but will be awarded in April. So the question of construction answers that complaint in my submission. It's simply the reflection of the meaning of the words when that contract is formed. The next step in the legal analysis is the effect that this has under UAE law. That's to say, the effect of the effluxion provision in clause 7. And to start with that, may I begin at page 1373 of the authorities bundle. This is the content section of the Civil Code.
Hold on. Uh, 1373.
1373. And it's just to get an idea of what the code is doing and how it's structured before one delves into its provisions.
Yeah.
So there are introductory provisions that start at paragraph 1001, within which part 5 defines rights. The scope and the exercise of rights, the abuse of rights, types of rights, and how those rights are proved. Book 1 then sets out obligations or personal rights. And within that, over the page, part 1 deals with contracts. And within that, the structure of the code is that there are general provisions in section 1, provisions in section 2 as to the elements, validity, the effect of the contract, and options. Section 4 deals with the construction of contracts, and then section 5 deals with dissolution and revocation of contracts.
Mm-hmm.
That's important because section 5 is doing a specific thing. It is dealing with termination for breach or by judicial order, not by expiry of the contract through performance. Your Honour sees that.
Where do I find that?
It's page 1467. Which is the Ministry of Justice commentary to section 5. So John has that. Section 5 is the dissolution.
Sorry, it takes ages to.
It's all right, don't worry.
1467.
1467.
Sorry, hold on.
This commentary at paragraph 20312 provides a general introduction to section 5 dealing with dissolution of the contract. By dissolution of the contract is meant it's ceasing to exist after it has been concluded as a valid and effective contract and before it has been performed. It does not include the expiration of the contract, which is it ceasing to exist after it's been performed. So section Article 271 and 272 has no relevance to a simple expiry through performance of the sort that clause 7 is dealing with, when the main contract simply expires. While I'm on this page, at a later point in the argument, when it comes to whether or not contract at will or contract ad hoc exist. And this passage is also drawing attention to the fact that there are some kinds of contracts that are termed non-binding under a UAE law. So the next paragraph, the rule in Islamic jurisprudence is that it's not open to either of the parties to contract unilaterally to cancel the contract by his own act, unless the contract is non-binding on him, either because of the nature of the contract itself or because it is accompanied by one of the options giving such contracting party the right to cancel. So there is a particular feature of UA law that introduces a non-binding contract, which is one where there is an option for one of the parties to cancel it. And I'll come back to that, but I simply draw attention to this stage that it's not within section 5 of the code that one finds provisions that deal with non-binding contracts and options to cancel. An illustration of that, which I use no more as an analogy, is the articles that relate to McCullers or works contracts. If one goes to 1531, which is in the same text, that recognises in Article 892 that this sort of contract can terminate simply by performance of the work. So a contract to McCuller shall terminate upon the completion of the work or upon the cancellation of the contract. So it's quite possible to have a contract that you discharge it through performance, it comes to an end. And Your Honour, that analysis is supported by a number of learned texts, which I'll go through at this stage. The first of those is at 721 of the bundle.
Yeah, hold on. Page 721.
721. This is an article in the Electronic Journal of Islamic and Middle Eastern Law, which is a peer-reviewed journal by is Heshmatullah Samavati, and it deals specifically with termination of agreement under UAE law and judicial precedent. The bit to which I draw your Honour's attention is at page 5 internal of that, which is 728. No, sorry, page 2, 725.
Yeah.
And in section 2 of that, there's a definition of termination. And the author says that when a contract is valid and enforceable, it must be executed. The execution is the natural way for the termination of the contractual relationship. And by that, the contract dissolves. So recognition that through performance, the contract will dissolve. There is also more general authority in relation to Islamic jurisprudence, which is at page 61 of the bundle. In fact, I might just go to the cover page so that Your Honour sees what one's looking at. It's page 59. That's an article on the dissolution of contract in Islamic law, published in the Arab Law Quarterly in 1998. And the bit to which I was taking Your Honour is at page 61. And under grounds for dissolution, the last sentence on that page says that Niazi contends that a contract is discharged, 1 by performance, 2 by express agreement, 3 by operation of the doctrine of frustration, 4 by breach. And over the page at page 62, the second substantive paragraph, Sanuri holds. I draw attention to this because of the authorities which my learned friend relied. Sanuri holds that by cessation of contract is meant dissolution rather than its formation as valid and enforceable, and before the completion of its execution. So cessation is used by Sanuri to mean premature termination, not performance. And it continues, and therefore he excludes 2 things from the discussion, namely cessation by execution or extinction. And in the next paragraph that's discussed, cessation by execution or extinction, this is due to the fact that a contract usually ends upon the fulfillment of the obligations arising out of it. And then just continuing a few lines down, a time-bound contract may end with the extinction of a fixed period of time, because the period of time in such a contract may extinguish with the extinction of the period, because the period of time in such a contract is a vital element. Nothing in that discussion draws any distinction between the performance of a contract for a fixed period and the performance of a contract day by day. In other words, if there is a contract that is ad hoc, that exists so long as one is performing it day by day, it expires in my submission. It doesn't terminate under Section 5 of the Code. And Your Honour, if that's right, no court order was required in respect of the termination under Clause 7. And when one comes later to analyse the contract that the parties entered into by conduct, nor is a court order required to terminate the ad hoc contract. I'm simply not focused on Section 5 of the Code, but the more general provisions about the performance of contracts.
So, sorry, just make sure I've got your point. A contract to perform day by day expires when there's no longer performance.
Yes, whenever the parties decide on any day that they're not going to perform it.
And is it within the gift of one party to decide that, or do both need to decide that?
In my submission, it is open to either party to terminate on that basis. And the analysis is either because there is no further agreement that compels the party to perform any further day, or because the very nature of that contract is that it is a non-binding one within the definition of the Code. In other words, there is the option for either party to decide not to perform on the next day.
Yeah, thank you.
Your Honour, I'll then go through the evidence of what happened in relation to this. I did this in opening, but it might be worth, if not to take Your Honour to the pages, to at least identify where those pages are, so that Your Honour sees what the timeline was of the Spanish contract. And this is in relation to the point that it expired on the 25th of February 2023. The original contract is expressed for a term of 3 years, subject to extension by mutual agreement, and says that it says expressly the maximum range of these extensions shall be 2 years. That's page 2215 of the bundle. The first extension exercised a 1-year option of extension until the 12th of December 2020. That's page 2657. The second extension, which is the second option up to the 12th of December 2021, is at 2854. And within that, there's an express recognition that the maximum scope of such extensions will be 2 years, and that the Spanish ministry wishes to extend the contract for a second and last year.
Yeah.
There's then the document at 1494, which recognises that there was an extraordinary COVID extension up to the 24th of May 2022. And within that same document, it provides a further extension for a 9-month period from that date, 24th of May 2022, expiring on the 25th of February 2023. That's what brings the original Spanish contract to an end on the 25th of February 2023. There is then a new emergency contract at 3114, and that has it's dated the 22nd of February 2023 and has an express term commencement date of the 25th of February. That's clause 3.
This is the emergency contract.
Yes.
Expiry when?
It's until the conclusion of the contract was under procurement. And so it expires on the 13th of April 2023, that being the date of the new contract at page 3246.
Yeah.
So that is the analysis by which the Spanish contract comes to an end. I move on to the next question, which is what replaced those from 25th of February 2023. And my submission is it was an ad hoc contract formed by conduct for which there was no further fixed term. As to this, again, the legal principles I'll just go through very briefly. First is at page 1402, which is within the code. Article 132 within that.
So you've got to give me a second.
Sorry.
1402.
1402. (132) provides an expression of intention may be made. It provides various forms. And the one with which Your Honour is concerned is 3 lines down. By an exchange of acts demonstrating the mutual consent, or by adopting any other course in respect of which the circumstances leave no doubt that they demonstrate mutual consent. So circumstances that leave no doubt as to the mutual consent. And that is a general expression of how the contract can be formed. It does not override the requirements for offer and acceptance, that's Article 130. For there to be an expression of intention to create a contract, that's Article 131. For correspondence between offer and acceptance, which is Article 140. And that there should be consent which extends to the subject matter and basic elements of the contract. I will go through to those provisions, which are at 1407. Article 1411 provides that a contract will not be concluded save upon the agreement of the 2 parties to the basic elements of the obligation, and the other lawful obligations that the parties regard as basic. And again, by way of analogy only, one looks to contracts for work, McCullers. If one goes to 1526, one of the matters that needs to be agreed in respect to that sort of contract, under Article 874, is the period over which it is to be performed. So in the case of the McCullough contract, there must be a description of the subject matter. And
Sorry, again, I've lost you.
Sorry, it's 1526.
All right.
And it's the 3rd line, the things that must be included in the McCullough contract. One is the period over which it's to be performed. So in light of those principles, I looked at the evidence as to whether or not it was unambiguously agreed that there would be any fixed term in respect of the contract that was formed by Conduct in February 2023. There are in my submission a number of
remind me what a McCullough contract is.
It's a contract for work, usually work and services, which in English will be a contract for labour and materials, but it's a little bit broader than that.
Yeah, sorry.
And I was looking at the evidence as to what the parties thought or agreed by February 2023. And in my submission, the first key point is that Mr. Comuni knew at the start of the subcontract, that's to say in December 2016 through to March 2017, that they were for a fixed term and that they would need to be renegotiated. And the evidence of that is on day 3 at pages 51 to 52. He knew by the 28th of November 2021 that they had put in a new tender. That's to say the claimant had helped the defendant to put in a new tender. So they knew there was a tender exercise by the 28th of November 2021. That's page 2878 of the main trial bundle. I will take you on to the next document, which is at 3061 of the trial bundle. And this is a chain of emails in May to June 2022.
In which, let me find it.
Sorry. 3061.
Yeah.
This was a chain of emails in which there was an attempt to try and re-agree the financials for the KSA contract. And that started at page 3063 with Mr. Shikhar Agarwal explaining the numbered points 1, 2, and 3, why he thought those were unfair. And then about halfway down page 3063, he asked, in order to continue this relationship, we need to revisit our commercials ASAP and start with new commercials from July itself. The response to that is at 3061 from Mr. Kamuni. And the bit that I took him to in cross-examination was at 3062. He sets out in the numbered paragraphs, going contract by contract, justifying the commercials under each of those. And then in the subsequent paragraph says this: we are unable to revise these figures now, knowing that the tender is currently ongoing, without a clear horizon beyond this year. The next paragraph, having said that, once the outcome is clear, we have a normal contract horizon, we're open to look at the commercials. This time we'll go beyond % value-added services bargaining and shooting numbers in the dark. We should establish the principle of balanced net profits. So, Your Honour, by June 2022, in fact, this is 6th of June 2022, Mr. Kamuni was aware that there was going to have to be a renegotiation in respect of the contract that was currently under procurement from the Spanish government. I asked him about that in cross-examination, and one has that at day 3, page 72, in which he clarified that he was expecting a renegotiation. The next document one has on the 19th of November 2022, which is a text between Mr. Agarwal and Mr. Kamuni, which acknowledges that the award has been made, but the contract hasn't yet been signed between BLS and the Spanish ministry. That's supplemental bundle 203. And Your Honour, just in terms of chronology, that comes just a few days after the winning bidder is identified in the procurement exercise on the 17th of November 2022. And Your Honour gets that date reference from the Spanish judgment in the procurement challenge at page 3152. In light of that factual background, by the time one gets to February 2023, the key evidence in relation to what happened comes first from Mr. Kamuni at day 3, pages 80 to 82. He's dealing there with, I was asking him, you knew in May 2022 there was going to be a commercial renegotiation. You knew in November 2021 that there was a bid being put together. You knew in November 2022 that an award had been made in principle. So around this time, you must have been anticipating we're going to have another negotiation. His answer is yes. I knew for sure it will come. So there was an anticipated negotiation that was due to happen. I then continued to ask him, well, what did you do? And I asked him, so all that happens in February 2023 is you all keep going. And he says, for me, you have to understand the frame of mind. We have a BLS won the contract, won the tender. This is the news I got in November 2022. So, okay, great news. As per our contract, we're continuing. This is the frame of mind I'm entering. This really is, I'm continuing. So nothing happens other than they understand things are continuing. That continues over the next 2 pages. Mr. Sahu's evidence is to the same effect. That starts in his witness statement at paragraphs 12 and 27. That's page 1020. And he reinforced that in his cross-examination on day 4, page 107. So in my submission, the effect of that evidence is that the parties simply continue. There was no discussion about any fixed term. There was no discussion of a contract continuing, certainly not until the end of the new concession contract, which by this stage was nothing more than an award in principle. The claimants then place reliance on conduct, which they say unambiguously had that effect. And in respect to that, Mr. Kamuni relied in his witness statement and cross-examination on essentially two things. The first is a discussion that he has with Mr. Agarwal on the 13th of October 2022. The document relating to that is at 2876. And Your Honour, that simply has nothing that comes back from Mr. Agarwal that could conceivably give rise to a fixed term contract. Nothing in Mr. Kamuni's initial email other than point 2 at 2877 is the closest that one comes. He says he also looked to extend the countries who manage for BLS within the Spain or the other new projects. And the response, in fact, there is no response, but he chases that at page 2876 and simply asks, regarding point number 2, we await update from your side based on the ongoing tender. So there's nothing in that discussion that could give rise to a fixed term contract. Again, I asked him about that on day 3 at pages 83 and 85. The second conduct on which the claimants rely is the instructions that were given, they say, to implement a Spanish visa system. And they rely on that because the Spanish visa was a new product under the concession contract, and therefore they say it must unambiguously give rise to an understanding that that contract was going to be extended throughout its entire length. The two documents that relate to that are first at 3450. That is entirely a communication between the ministry and the claimants, to which the defendant was excluded. So a number of the defendant's witnesses gave evidence in relation to that, but this is a communication to which the defendant was not kept informed. It cannot, in my submission, give rise to any understanding of a fixed term between the claimants and the defendant.
So it's between whom and whom? It's
between Miss Buparada, who is, let me get it right, I think she's the consul in Lebanon. Yes, so one gets that from page 3452. She's the chargé d'affaires of consular matters in the Lebanon embassy.
And she's communicating with whom?
With Miss Ayoub, who is the operations manager for the Lebanon VAC.
Yeah.
Of the claimants. The high point, therefore, of the claimant's case comes from the document at 3461, which relates to the same subject matter and involves the defendant. And again, the submission in relation to this is the defendant's giving instructions, but nothing in it would suggest that there was any long-term contract or fixed term being agreed. One starts at 3461, which is an internal communication from Mr. Batnagar to Mr. Kurian, Mr. Anand, and others at BLS. That simply says, we need to quickly move out the non-Schengen operations from Spain back at Lebanon. This is quite urgent, and we need to respond to MOFA. That's passed on by Ms. Kurian to Mr. Makahal at 3460. it asks for the Brazil operation to be moved into a separate facility, but there's no reference there to any contractual discussions. And then at 3458, that explains the nature of the change that was occurring. If one looks at the third paragraph, it was the Brazilian embassy was being moved out from the into the same building, but in a different area of it, in order to separate out the Schengen and non-Schengen areas. But again, there's no discussion anywhere in this chain of emails which would suggest an extension of time of any fixed period. So, Your Honour, the totality of the evidence in my submission is that by the time that the contract was formed in February 2023, they are simply proceeding ad hoc, day by day. My learned friend in his submissions suggests that that changes at some point in April 2023. No document has been identified to suggest why that is. And presumably it's to do with the granting of the concession contract. But it was Mr. Kamuni's evidence that there was no negotiation at any point between July 2023, when the parties start their email thread. That's the only contractual discussion that occurs about this in relation to the new concession contract.
So when you say the concession contract, you mean the new ministry contract?
Exactly. They call it a concession contract, but I think that's the procurement language, but it's the April 2023 contract between BLS and Spain. In consequence, Your Honour, this was simply an ad hoc contract continuing day by day. That has an impact both on the legal analysis for the reasons that I've submitted, but also on the loss analysis when one gets down to that. Mr. Girard has looked at a number of scenarios, most of which assume a long-term contract. I'll come on to that in a moment, but effectively my submission is this was a contract that was always at risk unless something else was negotiated. And that takes me into my third limb of my submissions under this part, which deals with the negotiations that took place in July 2023. And the key submission there is that this was a negotiation for a new contract. If it broke down, then it would mean the parties would simply walk away. It wasn't therefore an exercise of a termination right, but the analysis as between the parties failing to reach agreement on the one hand, and the parties terminating because there was a right to terminate, might affect the analysis of the non-compete obligation. And the reason for that is, if one simply walks away, the non-complete obligation would continue to the extent that it was ever valid. If, on the other hand, there was a termination of the contract, then that would bring to an end the contract in its entirety, including that clause. I'll go through the law in a moment, but I'll just draw that distinction when going through the negotiations. The starting point to this picks up on the email that I took Your Honour to from May 2022, a moment ago. In that exchange, the parties had not only anticipated negotiation, but had started to exchange what their prices were going to be. Mr. Agarwal had made clear that he wanted a relatively high rate of the value-added services, and he had set out what he wanted his fixed rate to be. Mr. Kamuni, on the claimant's behalf, had also set out that he wanted to restructure the agreement so that it would be not bargaining every year, but having a open books policy to identify what the to identify what party was entitled to be paid. The negotiations that we went through quite a lot in the trial, so I won't go through those in any detail, but they start at 3607, and it's a short chain of emails between 3rd of July going up to early August. Mr. Kamuni recognised that within that email, he recognised that there was a new mandate that had been signed. He did that in day 3 at page 101. So he went into those negotiations, recognising there was a new Spanish contract to be negotiated. The initial exchanges of correspondence were, as Mr. Kamuni identified, a price discussion. And he recognises that at day 3, pages 98 to 99. He also recognised that this was a commercial negotiation. There had to be agreement in order for matters to be taken forward. That's day 3, pages 105 to 106. I invite Your Honour to accept that Mr. Sahu went into these negotiations in good faith. He was expecting an agreement with the claimants on price, but they ultimately concluded that they were not in the best interest on the terms that were being put forward by Mr. Kamuni. And Your Honour, there is a degree of consistency between that and the earlier exchange in May 2022, where it was obvious that there was some difference between them as to where they wanted this contract to go. But that evidence comes from Mr. Sahu's witness statement at page 20, paragraph 26. That's page 1023. And Mr. Anand's
what paragraph number?
Paragraph 26.
26.
Yes. And Mr. Anand at paragraph 30, which is page 1036. And Your Honour, the key oral evidence in relation to this comes from Mr. Sahu. He was asked about this on day 4, page 168. And there he says that he went into this, that his understanding, in fact, I'll read it out. Our understanding was that because there had been a long-standing relationship with Mr. Nidal, we were quite confident that he has indecipherable to complete understanding of the costings, and it would, the best quote would come from him. So at that moment of time, there was no thought about going in and actually doing negotiations with other partners. So they went into this negotiation in good faith, expecting there to be an agreement, and that continues until a relatively late stage. It's not until late September 2023 that changes. The reason that changes was a loss of trust because of the number of the Iran incident. And that is Mr. Sahu's evidence at page 35 to 36. Sorry, day 5, pages 35 to 36, in which he says, starting at line 22, this particular incident was a deal breaker for us. It happened locally there, and the team has not informed us. Rather, they've tried to cover it up with the local embassy. Then they've submitted their reports to the local embassy, consulate, and this wasn't informed to us until the time it got escalated to Madrid, and then it came back to us. And after that, we have been having series of discussions in Madrid, because this is one of the most serious events that can happen and can terminate your contract, the whole global contract of BLS.
Can I just ask you, because you've mentioned good faith once or twice in the course of this, but your primary case is that there's no obligation of good faith when you're simply negotiating a new contract?
Exactly. So not to negotiate, because one isn't exercising a contractual right.
Yeah.
It's slightly different when one terminates, where there might be an obligation to exercise good faith.
Yes, I see.
But even that is within confines.
Thank you.
And Your Honour, the second passage I was going to draw to Your Honour's attention is day 5, page 13, in which Mr. Sahu again sets out between lines 5 to 22 why those negotiations came to an end. In short, there was persistent late payment of debts due to the defendant under the subcontracts, a serious data breach at the Tehran embassy, and the commercial terms weren't capable of agreement. The final aspect on this, I recognise that it's not the evaluation of bad faith when one comes to the reasons for termination aren't necessarily evidence-based in the sense that one person's opinion of that is only a factor. Mr. Kamuni's understanding of this was heavily premised on his belief that there was a long-term contract in place. He thought this was bad faith because he thought that he had an entitlement going through to 2028. And that comes in the passage of his cross-examination at day 3, pages 110 to 113. In relation to the Tehran data breach, I just want to identify a number of documents to draw to your honour's attention. The first is the notification of that directly from the Spanish ministry to Madrid on the 10th of July 2023. That's supplemental bundle 332. We don't need to go to it now, I don't think. Mr. Sahu's response to that, supplemental bundle page 343. I'm just checking the page reference as I go through. So he responds to the regional management team and says that this is critical and considered to be one of the clauses in the contract, which leads to a real risk of our cooperation agreement. And he responds on the same day to the ministry that he would initiate an investigation and send one of BLS's security managers to the centre to take stock of the situation. Mr. Annan's response is at supplemental bundle 343 to 342. And his response was, how come this wasn't reported to us by any of the team on the ground? And Ms. Kurian's response directly to the claimants on the 11th of July, that's 3478, the bundle, was to the effect that this was an extremely urgent matter and a complete violation to the sanctity of the application handling process, which has become a grave issue, which is being raised by the Spanish ministry to us instead of the team on the ground with BLS. What followed in the subsequent investigations, and those investigations are an initial explanation that's given by Mr. McCahal on the 11th of July at 3485, and then in a fuller report that's given at 3479. Those two reports revealed the following. The incident had occurred several weeks earlier on the 21st of June 2023. In the intervening time, the employment of the employee had been suspended and then terminated. That termination is on the 2nd of July, and the document for that is 3475. And there had been intensive investigations and calls to applicants to the visa centre that had been undertaken both by the embassy and by the claimants themselves. In his oral evidence, Mr. McCahal accepted that he had known of this incident a week before it was communicated, even in his email of the 11th of July. So, Your Honour, the breach wasn't simply the incident, it was the absence of notification on a contract that is, on a contractual obligation that is central to BLS's reputation and to the continuance of the contract. I will just summarise that obligation because it's important. It starts directly from the visa code. So if one looks at the authorities bundles at page 230, that has the list of mandatory obligations that have to exist in any contract between a government and the external service provider. Point A requires, in relation to the performance of its activities, the external service provider shall, with regard to data protection, prevent at all times any unauthorized reading, in particular during their transmission to the diplomatic mission or consular post of the member state. Point E, ensure all the technical and organizational security measures required to protect personal data against unauthorized disclosure or access. And then over the page in section D, it has another obligation in relation to the general requirements. The external service provider shall adopt appropriate anti-corruption measures and respect fully the provisions of the legal instrument, which shall contain a suspension or termination clause. So those obligations come from the primary regulation and are mandatory in relation to the contract that BLS had with its government appointee. there was also a notification obligation that comes from the same provisions, which filtered through into the subcontract. So we looked at the subcontracts and clause 3 of that. That's page 2227 of the bundle. I don't think we need to turn to it. That required the claimants to strictly adhere to the RFPs. Annex B to that, at page 2235, required the claimants to arrange sufficient security provisions and, through BLS, to notify the Spanish government of any security breach. And then the RFPs themselves, at pages 2136, and then specifically at 2151 and 2153, mimicked the obligations and the regulations. So they incorporate into the subcontracts, through the RFPs, the obligations that were critical as between the Spanish government and BLS. So in relation to that incident, we rely on it not only as a breach of contract when I come on to that, but the primary point is, at this point in the negotiations, it was something that was going to cause concern as to the ability of the claimant to continue to perform to the requirements that were necessary by the Spanish government. Right, turn next then to, even if I'm wrong on that, and there was no entitlement to walk away from these negotiations, nonetheless, the ad hoc contracts were validly terminated because of the claimant's non-payment under the subcontracts. The relevant breach is late payment. That is both as a matter of the way in which it was put in the payment notices, but also in fact. And as a result of the response that received from that, the notified default had become incurable. Again, it's worth just picking up the termination clause, which is 2302 of the bundle. We're now focused on the second paragraph of this. Either party may terminate this agreement immediately by a written notice to the other party in the event of a material breach by the other party.
2302.
2302, sorry. And I'm looking at clause 7, term and termination. And the second paragraph. I've already focused on the first one in relation to the earlier points. We're now looking at the second paragraph.
Yeah.
Either party may terminate this agreement immediately by a written notice to the other party in the event of a material breach by the other party, if the breach is not curable. Whereas if the breach is curable, then the termination shall have effect upon the expiry of 60 days from the notice intimating material breach, if it's not cured within the said period of 60 days. Now, the first line of that provides for termination immediately. And that is inconsistent with an obligation to go and get a court order for judicial termination. But it provides this clause for two bases for termination. Either if the delayed payment was incurable by the 19th of September, or if it was curable, but the response to it made clear it wasn't going to be cured. But in either of those alternatives, what one is focused on is what was the nature of the breach that was being asserted, which was you haven't paid us within the cycles of the contract. And that is the breach that became incurable, well, which wasn't curable from the start, but became incurable because of the response to it. It is not a cure to a delayed payment to say, I'll pay you in another 60 days. I need briefly to look at the pleading in relation to this, because there was a point at trial that appeared to be relied on. Looking first at the particulars of a claim, and it's page 115. This asserts in paragraph 32 the wrongful termination claim. So it's for the reasons set out above, by no later than around May 2023, BLS had determined that it would purport to terminate the Spanish and Cyprus contracts regardless of its contractual right to do so. And the termination or the wrongful termination is pleaded at paragraph 33. By the 1st of October letter, in breach of contract, BLS wrongly purported to terminate each of the Spanish contracts. I need to go up a little to look at the payment terms that were being asserted. And they are at paragraph, page 109.
Mm-hmm.
And at paragraph 21, what's pleaded at this point is, in addition, pursuant to Annexure C of the contract, the sums payable were to be computed on a fortnightly basis and deposited in the nominated designated bank account of BLS within 7 days from the fortnight so computed. And the amendment to that was alleged to be, however, the parties subsequently agreed and proceeded on the basis the payments would be made on a 30-day schedule subsequent to fortnightly invoices, in effect around 6 weeks from the end of the period to be paid, as agreed by Mr. Anand of BLS in an email of the 6th of September. Now, that was modified in the reply, and it becomes far more simple. Looking first at the defence, that's at page 144. Now, I'm just analysing at the moment what we said about the payment notices before, in other words, the nature of the breach before I come to the payment terms. Paragraph 54, we're pleading the response that comes from Mahmoud Hussain on the 27th of September. And at 54.3, we say that that response was misconceived. The material breach identified in the defendant's default notice was a failure to pay sums under the new KSA contract when they fell due, and we emphasise that. So it was non-payment on time. At paragraph 56 over the page, we assert that in the circumstances, by the 1st of October 2023, Access had 1, ceased making payments under each of the new Spanish contracts and had not accounted for any services supplied since June 2023. 2, had repeatedly ignored demands to make payments under the terms of the contracts. And 3, had rejected the default notice served under the new KSA contract. By that conduct, it or they evinced an intention not to perform the contract in accordance with their terms, and not to cure, if it was curable, the breach consisting of persistent delayed payment. So our case isn't, has always been, that by the time we get to October, there had been persistent delay in payment. And that's the breach that we're asserting both in the notice and as the entitlement to terminate. And 57 therefore asserts, in response to paragraph 33, we were entitled to terminate. So my own friend is not right when he said at trial that the history of non-payment wasn't an issue. It was, because we've asserted persistent non-payment. As to the terms of, that we were asserting of the payment terms, that's at page 134. And at paragraph 38, we respond to paragraph 21 of the particulars of claims. And we say, in paragraph 38.2, it's admitted that the parties agreed to extend the time for payment under the clause of the Spanish contracts pleaded in paragraph 30.2 above. The defendant permitted payment within 30 days of the end of the relevant accounting fortnight. So that is a straightforward assertion that you get to the accounting fortnight that ends on the 15th or the 30th of each month, and you extend the period of payment for 30 days from that date. Nothing about invoices, nothing about end of month. It was simply that being asserted. The reply admits that, and that's at page 175. And at paragraph 32, this responds to the paragraph just taken on a 2. And at 32.1, the second sentence of paragraph 38.2 is admitted and averred. So express admission of the terms of payment that we're asserting 30 days from the end of the computation period, from the end of the accounting fortnight.
Sorry, paragraph, what was it?
It's paragraph 32.1.
Oh, yeah.
So, Your Honour, in analysing this evidence, whether or not there was persistent late payment, one doesn't, in my submission, really need to go beyond the September 2022 meeting at which the asserted 30-day payment terms are agreed. In other words, they're reasserting we're going to stick to this 30-day period that's set out in the pleadings. And the email relating to that is at 3075. And that doesn't, in my submission, leave much scope for debate. Point 1, BLS raised the concern of payments not being made within the 30-day schedule by Access Group. Point 2, in some cases, the delay was beyond 2 months. 3, Access Group requested BLS that the payments be made on completion of month. And point 4 is the key one. Access Group will streamline all delays and ensure payments are made on time going forward. And Mr. Kamouni's evidence in relation to this so it's day 3, page 124 to 125. I asked him, the purpose of that meeting was for BLS to express concern about the late payments that your companies were making. Yes. Then after a few more questions, so the outcome of this meeting was that you were sticking to and reasserting the 30-day period that I've just asked you about. Response, just if you read that same paragraph that you just mentioned, it says indecipherable about 30 days. It's refocusing on the 30 days because in some cases with the agreement of BLS, it was actually 60 days. So it's reasserting the 30-day payment terms that are identified in the pleadings. You know, in terms of the timescales for this, after that meeting, in January through to August 2023, there were in my submission consistent demands for payment, which were made by WhatsApp between the respective finance managers on each side. An illustration of those is 3786 down to 3798. We don't need to go to those, but that's the WhatsApp messages. On the 25th of August 2023, Mr. Sharma sends an email demanding payment of what he describes as long outstanding debts due since June 2023. That's at 3772. The claimant's response to that on the 18th of September is at 3771 down to 3773. And it was saying it's unable to say when or if payment would be made. And Mr. Sahu's evidence in relation to that, that's day 5, page 30. He says between lines 12 to 16, well, I would say this is another response which says hopefully we'd be able to do the payments and a progress had been made locally. And by that time, we knew that there were issues between Access and their local subcontractors. So he took it as another response along the lines of at some point we're going to pay, we're not going to tell you when. It didn't resolve the problem of delayed payment. And that's what leads to the demand that's made on the 19th of September 2023 at 3783. Again, I won't go to that. We canvassed it extensively at trial. It was a complaint about late payment. It therefore complained that as per Annexure C of the MOU, the business partner shall, on receipt of an invoice from the company, pay all amounts as per the agreed cycle. The response to that on the 27th of September, 3852 to 3855, made clear that that was being rendered incurable, in that it denied any debt was outstanding and used the termination provisions to eke out a further 60 days in order to pay that. That plainly, in light of the nature of the breach being asserted, didn't cure it, but aggravated it. And Your Honour, that leaves us with the payment schedules, which provide a broader basis of evidence in relation to whether or not this was a breach that had in any way got better since September 2022. Mr. Gupta's schedule is at 3889. And Your Honour, the bit that probably one needs only to look at is from September 2022, which starts on page 3899. In my submission, on the pleading as it exists on the dispute that exists on the pleadings, in any payment where the last column shows anything more than 20 days, and the reason for that is Mr. Gupta gives 10 days for payment from invoice, and so anything over a further 20 days beyond that would be the 30 days after the computation period, would be a delayed payment. And looking through from September at page 3855, it didn't get any better from that communication in September 2022 when the heads of finance met, right through to the termination date, over on page 3900. Now, because of the dispute that's on the pleadings, the contrary table that's been produced by the claimants is not in my submission meaningful in order to resolve this dispute. One gets a short summary of what that does in my learned friend's cross-examination, day 7, page 157 to 159. Now, I draw that to Your Honour's attention simply because it encapsulates in a few sentences everything that schedule does, which is inconsistent with the pleaded case that I've taken Your Honour to. What it does, it takes account the actual invoice date rather than the date that's given on the invoice, the actual date of payment, and it allows 30 days from the end of the month where there are two invoices. None of that is canvassed anywhere in our pleaded cases. For those reasons of my submission, come the 1st of October 2023, the termination notice was valid. It was certainly valid in relation to the KSA contract, which is the largest of the claims by value with which Your Honour is concerned. In my submission, it's also valid in relation to the remaining contracts, because the response that had been given on the 27th of September can't be taken as a response to a single contract. They weren't saying, we're not going to pay you the KSA one, but for all the others, we're going to bring it in on time. It was a straightforward denial of the payment terms under any of these subcontracts. I turn then to the law.
Should we, I think probably we've got to give the shorthand, the transcriber.
Oh, yes. Okay. Sorry. Yes.
I don't know whether half an hour is enough or whether they want more. Lena there? No. Reem.
Yes, Your Honour.
Do the transcribers, how long would they want?
Hello?
I'm just trying to find out how long we should break for the transcribers. Do they need half an hour or
yes,
more than that or less? What?
If we break for 30 minutes, that should be okay for the transcribers, Your Honour, as you seem fit.
Okay, well, let's break for 30 minutes. So we'll resume at, I'm not sure what time you have now, but in half an hour's time.
It's 3:24 p.m.
Right. Well, we'll resume at past the next hour. Sorry. We'll resume on the hour at 1 o'clock UK time.
Thank you, Your Honour.
Certainly. Thank you, Your Excellency.
Thank you very much. Yes, Mr. Oram, I think we're ready to begin.
Yes, thank you, Your Honour. I just left off before the break. I was about to start on the law on a number of areas. I want to address at this point the key point about the operation of the termination provisions And at the same time, I'll address what the effect of termination is, which is relevant to what happens to the non-compete provision. The starting point to this is in the authorities bundle in the Civil Code. We're looking at page 1470.
Yeah.
And there is a distinction between Article 271, which is an agreement to terminate, and Article 272, which is a judicial order for termination. We're focusing for the moment on Article 271, which states that it should be permissible to agree that a contract shall be regarded as being cancelled spontaneously, automatically, without the need for judicial order upon the non-performance of the obligations arising thereout, and such agreement shall not dispense with notice. Now, it's worth just bearing in mind again the wording of the termination clause in this case. The key part of it is either party may terminate this agreement immediately by written notice to the other party. So on the face of it, it is saying it will terminate immediately once you serve a written notice and do no more than that. In terms of the general distinction between Article 271 and Article 272, the commentary over the page identifies its significance. So page 1471. The second sentence of that first paragraph, cancellation may occur by order of the court or by mutual consent of the contracting parties or by operation of law, and thus cancellation may be judicial, consensual, or by force of law as the case may be. And just continuing down towards the bottom of that page, it starts a paragraph as to consensual cancellation. As to consensual cancellation, the agreement of the contracting parties assumes a cancellation as a matter of law without requirement for a judicial order where there's been a failure to perform. Such an agreement will result in the contracting party being deprived of two indemnities. I'm not sure we would understand indemnities in the same sense, but two rights. And A is the contract will be conclusively cancelled without that contracting party or indeed the judge having the option between cancellation and performance. And B, a cancellation made by mutual agreement rather than by order of the court will not release the obligee from the necessity of taking the matter before the judge in the event that the obligor disputes the fact of performance of the contract. In such an event, the task of the court will be restricted to establishing that fact. So you can have a termination clause that says we will terminate in XYZ scenario. You may still need to go to court, but the effect of the limited role of the court in those circumstances is simply to declare the fact, the existence of XYZ. By contrast, 272 is a judicial order for termination. So it involves a discretion by which the court decides whether or not to permit the ongoing performance or to bring the contract to an end. In either event, and this is the bit about the effect of termination, on page 1472, just before paragraph 20325, there's a paragraph that begins, cancellation, be it judicial or consensual. Cancellation, be it judicial or consensual, or by operation of law, will result in the contract becoming non-existent with retroactive effect, and it will be deemed void ab initio. This will put the contracting parties back into their original position before the contract was concluded, and each of them must return whatever he has received pursuant to the contract after it has been cancelled. So it unwrites the whole contract, which is relevant in this case to the effect of the non-compete clause, if BLS is right, that the contract was brought to an end as a result of an agreed termination clause. There are then a number of commentaries that address what kinds of termination clause the parties can choose to draft. I'm just taking one or two.
I'm not sure I understand this paragraph you just read to me. Say it again.
So cancellation will result in the contract becoming non-existent with retroactive effect. So it's not unlike common law where it is prospective only. It stops the clock at the point of termination. Existing rights continue to subsist. Future rights are unwritten. Under UAE law, it unravels the whole contract. It's void ab initio.
So if you cancel after 2 years, for example, you get all your money back. They get all their money back,
except in relation to property rights that have been transferred. So
by property, you mean physical stuff.
Well, in this case, it would be, for example, the existing performance of the VACs for which money had changed hands. So that wouldn't unwrite that part of the contract. And where that comes from, the parts of the code that have that effect are 1474.
Mm-hmm.
Article 274 says if the contract is cancelled with or without a positive act, the two contracting parties should be restored to the position they were in before the contract was made. And if that is not possible, compensation should be ordered. And 275 specifically deals with the circumstance that Your Honour just dealt with. So if the contract is dissolved by reason of voidness or cancellation, or through any other cause, and each of the parties is obliged to return that which he has obtained, it should be permissible for each of them to detain what he has received, so long as the other party has not returned what he has received from the former or provided security. So if you're unable in respect of past performance to unravel the contract, those existing rights stay where they are. But in respect to the non-compete clause, the contract will be treated as non-existent, as void ab initio. I was turning then, that of course is premised on termination for breach, either by judicial order or by an agreed provision. I was then moving on to look at two academic articles that deal with the nature of the clause and how that's drafted and what impact that has on the engagement of Article 271. The first of those is ARMCAN, which I've taken on to before. It's page 44 of the bundle. And the bit to which I'm taking on is at page 54. And at the bottom of that page, it provides sorry.
Yeah.
So under characteristics of the right to terminate by agreement, this is the explicit terminating condition to which my learned friend is referring to, as opposed to the implicit terminating condition. And the commentary says that termination by prior agreement differs from termination by a court order in that it's meant to deprive the court of its discretionary powers in deciding upon termination for breach. So that's the value of an express condition. Under stipulating for termination, the author then considers different ways in which you might draft that clause. So to achieve the desired result, a contractual clause intended to provide for termination in case of breach must be unambiguous and must clearly reflect the common intention of the contracting party to that effect. And then those clauses can be formulated in different ways. It gives 3 examples. The first is a provision that the contract will be terminated in case of breach, and that's regarded as reaffirming what is already provided for in the legislation. In other words, a reference back to the statutory provisions which provides for judicial termination. The second alternative, which is the next paragraph, a provision that a contract is to be terminated ipso facto for non-performance without a court order means that the contract is to be terminated upon the demand of the agreed party in the event of breach. The agreed party, however, is not relieved from placing the other party legally in breach by notifying him formally, in this kind of agreement, there's no need to seek a court order. The contracting party allegedly in default, however, might challenge the other party's decision to terminate, either by denying that he's failed to perform his contractual obligation or by arguing that his failure to perform as due to the other party's own fault. The sole function of the court in this event will only be to affirm, in the light of the contractual terms, whether in fact the breach which has given rise to the claim for termination has occurred or not. So the second alternative is providing for contractual termination ipso facto for non-performance without a court order. And all we need to do is be drafted in such a way that makes clear that it's to be terminated immediately on notice. A similar analysis is given in another article that I've already taken your honour to, page 721. This is dealing specifically in relation to UAE law.
Hold on. Yeah.
So this is Samavati, and I've taken your honour to page 730. Termination by prior agreement starts on this page. It recites in similar terms the effect of Article 271, and then cites a passage from first the Dubai Court of Cassation, and there's a first quote, and it's the second quote I'd like to look at. Termination by agreement means that the contract contains a cancellation by agreement clause, stipulating the contract to be regarded as being cancelled automatically without the need for a court judgment, when the obligations arising from the contract or one of them are not fulfilled. It's called the explicit cancellation condition, and then the termination here is definitely compulsory when the breach of the contractual obligation occurs and the contractor or the judge has no choice between the cancellation and execution of the contract. Here, the decision of the court shall discover the occurrence of the cancellation and does not create the contract termination status. And the immediately following sentence, the same court has emphasised that the law does not require specific words for the explicit cancellation conditions. With that passage, the author then considers various forms that the termination clause can take. The bottom of the page, firstly, sometimes the parties agree that if one of them fails to fulfil his obligations, the agreement will be deemed to have been terminated. On the one hand, such a phrase only illustrates the uncertainty in the general rule of termination and doesn't add anything to such a rule. And then over the page, the second example, which in my submission is this case, about halfway down the page, sometimes the parties agree on the contract to be terminated spontaneously. Such an agreement does not exempt the obligee to give notice or to not open a file in the court.
Do not give notice.
Sorry, to not give notice or to not open a file in court. However, it deprives the judge of the discretionary power and he has no right to give time to the obligor. So if you simply say terminate spontaneously, you may still need to go to court, but the function of the court is different.
Right.
It's simply declaring the existence of the fact that entitles you to terminate. It's not exercising a discretion.
Right. Are you going to tie this in with the present case?
Yes, exactly. So going back to the wording here, this is 2302 of the documents bundle, the trial bundle.
Yeah. 2302. Yeah.
And the central question is that second paragraph of clause 7, is that intended simply to reflect the existence of Article 272, or are the parties intending to go further than that and provide a separate right of termination? In my submission, it does the latter, and it does that for two reasons. First, it specifies when termination happens, may terminate this agreement immediately. That is inconsistent with having to go to court to get a judicial order. And secondly, it specifies the mechanism by which it terminates. So it's to terminate this agreement immediately by a written notice to the other party. Again, that is inconsistent with having to do that and get a judicial order for termination. So properly construed, what this clause is doing is not simply mimicking the implied condition in 272, but granting an additional right contractually to terminate without judicial order under 271.
Right.
The last authority that is helpful on this is a decision of the DIFC Court of Appeal in the case of DIFC Investments and ZIA. That's in the authorities bundle at 616. It's worth starting with the clause that the court was considering, which is at page 620. And clause 6 of that said that in the event that the buyer fails to pay the payments as agreed date in clause 3, or fails to complete the transfer on the agreed date due to his own act or omissions, then the seller has the right to terminate this contract and should be entitled to retain the deposit. So there was nothing in that clause that said you have to go to court to get a court order. And the question was whether or not that would give rise to an immediate right of termination. There was a dispute between the parties as to which system of law applied. And ultimately, it was decided that the DIFC law applies, not onshore law. But at paragraph 32, this is page 625, the court went on to consider what would be the position if onshore law had applied. And this is because there was a respondent's notice. So paragraph 32, the court referred to the fact there's no need for us to determine the position under the law of onshore Dubai. But at paragraphs 33 and 34, it did consider that. May I invite Your Honour just to read those two paragraphs?
Right.
So if my learned friend's analysis were right, then this case wouldn't have been decided in the way it was, because there was no reference to not having to get a court order for judicial termination, and yet paragraph 34 of the Court of Appeal's judgment indicates that the effect under UAE law was that it didn't dispense with notice, doesn't arise in this case, but it was otherwise effective to provide for termination by agreement of the parties. That, in my submission, is this case.
Yeah.
The last thing I need to address on this issue.
Can you give me a second?
Of course.
Unlike Dubai, it suddenly got very cold. Got to put a heater on. Yep.
I just wanted to address two further issues of law that arise on this point. The first is the suggestion that there was a right of suspension that was exercised. So in response to the payment delay, the claimant's suggestion that we didn't pay because we were exercising a right of suspension. The second is, if I'm wrong about all my prior submissions, what the court should do to exercise its discretion if we're in the territory of Article 272. I won't spend a great deal of time on that. In relation to the right of suspension, looking at the authorities bundle, that derives from Article 247, which is at page 1456. The key part of that provision in my submission is the need for there to be mutual obligations, one in exchange for the other. So interdependent obligations, as we would analyse them under the common law. Article 247 says, in contracts binding upon both parties, if the mutual obligations are due for performance, each of the parties may refrain from performance of his obligation if the other contracting party does not perform that with which he is obliged to do.
Yeah.
And so the classic example is payment for the price in return for the transfer of goods would be a sort of situation where a right of suspension exists.
Yes.
In this case, that doesn't arise.
It's what would be called retention in Scots law.
Yes,
Yeah.
Exactly. And the commentary over the page makes that point clear. One of the principles on which the system of contracts binding on both parties is based is the connection between the mutual obligations to be performed on the basis of mutual exchange.
Yeah.
So it has no application in these circumstances because the two obligations aren't interdependent. There's on the one hand the payment of the price, which is all in respect of historic services. And Your Honour will recall that the way this contract functions, applicants at the Visa Centre physically pay cash and credit cards. That is money in the bank. And that's simply passed on to BLS as part of its appropriate share. So it's all in respect of historic services, which we weren't getting paid by the 27th of September 2023, when the claimant serves its notice of, which is the only thing that can be a right of suspension, although it doesn't in express terms say that. There's one authority from the Dubai Court of Cassation that is relevant to this point. That's at 158 of the authorities bundle.
Sorry, page one.
158. And over at page 159, the relevant paragraph is paragraph 2.
Hold on.
Sorry.
159.
159.
Yeah.
And in paragraph 2 that it says, in contracts binding on both sides, where the performance of the mutually corresponding obligations is a matter of exchange between the parties, either of the contracting parties may withhold performance of his obligation if the other contracting party has not performed his corresponding and connected obligation. The question of whether there is a corresponding set of obligations and whether there is justification for a contracting party to withhold performance of the corresponding obligation is a matter of fact within the jurisdiction of the trial court. So that exercise of connection is the key issue in this case. I turn then finally on this point to whether or not the analysis is any different if one is under section 272 and a judicial order is necessary. In those circumstances, my primary submission is it wouldn't make any difference to the exercise of that discretion, although I recognise that such a discretion exists. Again, this is dealt with in the article to which I took your honour earlier, page 731. In the second paragraph on page 731, there's a citation from a decision of the Dubai Court of Cassation, which is dealing with this implied termination clause. It established under the judgments of this court that the termination based on implicit termination clause, established under the law for all contracts binding on both parties, as implied from Article 272, grants the obligor the right to avoid the termination by fulfilling the debt before the rendering of a final judgment in the lawsuit. This is the key wording, as long as it is not evident that the delayed fulfilment is alleged by the obligee. So if the complaint is about late payment,
sorry, about what?
Late payment, persistent delayed payment, then the analysis is the same, whether one goes on to 271 or 272. Because the exercise of any judicial discretion wouldn't be giving time for that to be done. It would in effect be altering the contract that the parties have agreed. If one is going down the 272 route, there is one additional breach that is relevant on the evidence, which is Mr. Tiara's evidence as to the way in which fees were collected by High Skies and not accounted to the defendant. Mr. Tiara dealt with that in his witness statement at page 1048.
Yeah.
Paragraph 27, you're maybe familiar with this. He's dealing with the travel agent who walks into the door in the Saudi Arabian embassy and shows a receipt showing that there's been more payment that's been accounted for. And he says that they looked into the system of the visa application center and saw that it had been recorded as 400 rial. The document to which he refers is at pages 3887 and 3888 of the bundle. 3887 is the untranslated, 3888 is the translation. So one sees from that that the payment was made to the beneficiary Smo Al Ajwa Travel. That's High Skies in Farsi, I think it was said. Mr. McCall's explanation at 1012 of the bundle in his witness statement so it's paragraph 69. His explanation was that it was not done with the knowledge, authorization, or involvement of the claimant's management, and that it was an isolated action of a single individual. That explanation doesn't tally with the fact that the payment was made to its subcontractor, to High Skies. I asked him about that in cross-examination. It's day 4, page 41, and put it to him that that explanation didn't justify what was being explained by Mr. Tiara. So if one is going down the judicial termination route, that is, in my submission, a breach that was made out on the evidence and that wasn't explained by Mr. McCall's version of events. Your Honour, I turn next to the question of whether or not the defendants were acting in bad faith at the point of termination. There's, again, a little bit of law that I need to take Your Honour to in the authorities bundle first. In my submission, the starting point is Article 104 of the Civil Code. That is page 1377.
Sorry, and this is what?
Page 1377. We're dealing with the question of abuse of rights. In the authorities bundle at 1377. Article 104 provides the starting point. The doing of what is permitted by law negates liability. No person who lawfully exercises his right should be liable for any harm arising thereout. The starting point in my submission that there was a contractual right to terminate. The exercise of that right doesn't give rise to any liability. The qualification to that is
sorry, you're going too fast.
I'm sorry. 1377.
Yeah.
I was looking at Article 104.
Right.
Which is the general provision, the starting point, that doing what is permitted by law negates liability. And I rely on that for the proposition that if what we were doing was validly exercising a right of termination, the starting point is that gives rise to no liability. It's not an abuse, it is the exercise of a valid right. The circumstances in which that changes is in Article 106.
Mm-hmm.
And there's 1378. 106.1, a person shall be held liable for unlawful exercise of his rights. And so, Your Honour, just going back a moment to what I was submitting earlier about the negotiations, if the negotiations simply fall apart, that's not an exercise of rights, that's simply the parties not agreeing. So that doesn't engage abuse of rights. But the question of termination, I accept, could engage Article 106. If it is an unlawful exercise of rights, and subarticle 2 prescribes when that might be. And that is, A, if there's an intentional infringement of another's rights. B, relates to public morals, which we don't need to concern ourselves with. C, if the interest desired are disproportionate to the harm that will be suffered by others. Or D, if it exceeds the bounds of custom and practice. Now, in my submission, the key one of these is A, whether or not the defendant was intentionally infringing the claimant's rights. Proportionality doesn't really lend itself to this analysis because it wasn't it was all or nothing. It was either they paid and we terminated and they would simply be privileged in future performance, but there's no engagement of disproportionality. But over the page in the commentary, there's an analysis of when that would apply. And just above numbered 1, it says the law lays down 4 specific rules showing when the exercise of a right is unlawful. And one is when the right is exercised solely for the purpose of damaging another person. This is subjective criterion to be found in Islamic jurisprudence. The essence of this is that a person should have the intention of harming another, even though the exercise of the right does in fact result in a lawful benefit being obtained. The intention to cause harm may be deduced from there being in fact no genuine interest served by the exercise of the right, and where the owner of the right knows that fact. So it is, in my submission, in relatively limited circumstances, although I accept it is evaluative, and all of the factors that we explored at trial will be relevant to that question, that key amongst them was BLS intending to harm the claimants at the point of termination? And if that's the right question, then it should be answered negatively, because they were exercising their rights in the face of persistent late payment over very many months in order to get paid. In terms of the evidence on this point, the way in which this bad faith point is asserted, the primary allegation is that BLS had been acting in breach of the non-compete clause for many months. The alternatives are broader than that. It terminated in order to wrongly seek to compete with the claimants. And thirdly, BLS acted in an underhand manner. One sees that in paragraph 37 of the amended particulars of the claim. Can I deal with the first of those? It is clear on the evidence that BLS had not, in fact, been acting in breach of the non-compete clauses for many months. The evidence in my submission makes clear that the claimants continued to perform the contracts until late September. The ending of their role in the visa application centres is around 27th, 28th of September. And so there is no competition until at the earliest, 27th, 28th of September, and probably not until early October. The evidence of that is that there had to be certain things brought into place before BLS could start to run the centres itself. And those were, first, the ministry giving approval, which doesn't happen until, in the case of Ghana, the 19th of September. That's page 4076 of the bundle. Secondly, it had to have staff in place in the visa application centres, and that didn't happen until mid to late September. One sees that at the supplemental bundle. If I start at 832, this is one of those embedded documents, but it's been reproduced elsewhere. I'm simply taking your honour to the page so that you're familiar with it. Where it is reproduced is supplemental bundle 1580. My learned friend asked our witnesses a number of questions about the date of joining, the last column of these staff. The earliest in time is Mr. Wasi, row 7 in May. There's then an operation manager who joined us on the 6th of August at row 6. I'm looking at the last column. I identify that. But, and then most of the other staff start in September, October, and November in respect of KSA. So BLS simply wasn't in a position to start competing until staff were in place in order to perform those roles. The next thing that had to happen is that Madrid had to be told that the changes in subcontractor were happening. And that happens on the 26th of September at 3871.
Supplementary.
I think it's a main bundle. Sorry, yeah. This is Mr. Sahu writing on 26th of September to the Ministry in Madrid in respect of all of the application centres. Consistently with that, drafts of the termination letter to the claimants don't come into play until the 27th of September. That's 3826, where it's discussed internally. It was Mr. Sahu's evidence that it was around this time, when this letter was being produced, that they had decided to terminate. That's day 5, page 46. He's asked about page 3826. And the question put to him was, so I suggest by that point you had, in fact, even on your own case, you must accept that you'd already taken the decision to terminate. The response was, well, I can't remember it clearly, but it seems from the email, I believe. So Mr. Sahu's accepting that it was around this time that the decision to terminate was taken. And consistently with all of that, staff aren't given logins to access the system until their activation in late September. So this is the subject of cross-examination with Mr. Anand. The document to which he was taken to was 3748. Which is in mid-August, asking about setting up usernames. His response was, these were at that point dummy accounts. They weren't activated. And in re-examination, I took him to 3909, which shows their activation on the 30th of September. And his oral evidence in relation to that is on day 6 at pages 18 to 19. Where there were that the initial user IDs were dummies and they weren't activated until October 2023. In my submission, that's supported by the documentation. So I invite Your Honour to accept the defendant's witnesses' evidence that they were taking preparatory steps from the point at which the negotiations looked as though they were going to falter. That doesn't start before 10th of July, when the Spanish ministry reports the Tehran incident. Until late September, they haven't formed a view, and they would have changed tack if they would have received payment from the claimants. And it was the fact that both of those events happening during the course of negotiations that means that they form a settled view, and ultimately a transition plan comes into play on the 18th of September. That's 3830. And Your Honour, finally on this point, that of course is consistent with Ms. Kurian's evidence that the claimants were continuing to perform these contracts until 28th of September. That's day 7 at pages 44 to 45. And consistent with Mr. Girard's calculations, from which he uses data that the claimants obtained while performing. There are numerous appendices that are all embedded, but one of them that has been produced in PDF form is Supplemental Bundle 2413. That's a spreadsheet for Lebanon, but the reason for drawing it to Your Honour's attention is the dates of it. So at 2414, we see that the last entry from the claimant's own records is on the 30th of September 2023, and that's matched in each of the appendices for the other centres. So there couldn't have been competition prior to that date because the claimants were still in charge of these application centres, and the ministry hadn't been informed that anyone else was going to be doing it. Your Honour, in relation to the whether there was an intention to terminate before then, whether there was a premeditated plan, on the 9th of June email, which seems to be the forefront of my learned friend's case, and I simply draw to Your Honour's attention the evidence of the defendant's witnesses. Mr. Sahu's evidence that the exercise they were undertaking at that stage was going to each of the regional heads to identify any weaknesses in the contractual documentation that they had with their subcontractors with a view to bolstering it. That's Mr. Sahu's evidence at pages day 4, 144 to 145. Mr. Anand gave evidence to similar effect. That's day 6, page 62. And Ms. Kurian gave evidence to the same effect, but amplified that in the course of having discussions with the lawyer who she instructed, a discussion came up about the sort of problems that it had previously had with the existing subcontractors, and that led into a discussion about the dispute terms and the arbitration provisions and dispute resolution clause. So that's day 7, pages 2 to 3. So that is the evidence from the witnesses. In my submission, it's corroborated by the dramatic change that occurs between the form of the subcontracts. On the one hand, those that were entered into with the claimants, and on the other hand, those that were entered into with Helen Holidays, Blueberry Travel, in respect of the post-takeover period. If one simply compares those two documents, one being at 2300,
Of the main bundle.
of the main bundle. This is the familiar subcontracts that we had with each of the territories of the claimants. And that was what was being bolstered in this exercise. The document that it was replaced by, looking, for example, at Helen Holidays on the 5th of October, is at page 4007 of the same bundle. And it is something like a 60-page document setting out in terms service level provisions of the sort that one would expect for contracts of this value. So, Your Honour, in my submission, one needs to give more credence to this evidence than my learned friend would give it. And one other document that I want to address is the Iran VAC rollout document, spreadsheet at 3762. This first comes into email correspondence on the 15th of September 2023. I recognise what my learned friend will say, that there is documentation that's missing, and I don't go behind that. Nonetheless, this is in the context of Mr. Mustafa being sent out to Iran around this time. So it is being implemented at the time that this email is being discussed. Over the page, the contents of it, in my submission, they support the view that what had been taken was preparatory steps. So nothing that was irreversible, and it was the defendants wouldn't have changed tack on if the payment had been made. And in respect of sorry, I'm just trying to find the yes, here we are. The metadata to which one was taken at 3266. There was quite a lot of debate about why this was produced on the date of 24th of April 2023. And my learned friend suggested in cross-examination, well, was this a document that was actually in existence in 2016? The template was amended in 2023, and that the only thing that had happened was that the defendant was trying to compete. Well, in my submission, the obvious answer to that is there was a very relevant event that was happening in April 2023, which is the new concession contract with the Spanish ministry. So in my submission, that doesn't take us any further. What it demonstrates is there was a general rollout template being done in all the territories, but it doesn't disprove the defendant's witnesses' evidence that what was happening was simply preparatory steps, which depended on whether or not the contract was to be lawfully terminated by the means that I've submitted earlier. And those are my submissions in relation to termination and how the contract ended. I want to move finally and relatively briefly to the question of losses. My submission in relation to this is that even if I'm wrong on everything so far, the claimants have not suffered on the evidence any more than a nominal loss. My learned friend asked the question in the course of his submissions, does the evidence support the fact that the profits were passed on? That, in my submission, isn't a relevant question. You don't create a loss by giving money to someone else. There has to be some entitlement to that, which is either through the structure of the companies, through our contractual entitlement, or perhaps some other legal route which entitles the claimants to claim the losses that they are claiming in these proceedings. Mr. Girard's calculations operated a methodology by which he first forecast the number of applications, so how many applications would have been processed in the post-termination period. That was all based on the defendant's figures, so nothing arises in relation to that limb of his calculations. He then identified the revenue per application and multiplied those two together. The revenue per application was based on the claimant's figures. Your Honour sees that in Mr. Girard's evidence. I cross-examined him about this on day 8 at page 30, where at line 11 I asked, so you've taken the claimant's figures for a 9-month period immediately before termination, and you identify the total revenue and the total number of applications. Yes, that's correct. And you divide the total revenue by the number of applications in order to obtain a per application revenue, and that's correct. So that all comes from the claimant's figures in the 9 months before termination. The third step in the exercise is that Mr. Girard applies a margin, or identifies a operating margin, which he then applies to the revenue to identify the profit element. And again, that's based on the claimant's figures. And the relevant part of the evidence is, again, day 8 at page 84. In that process, it's clear that Mr. Girard has included improperly revenue from entities that are not the claimants. So in his scenario 2.3, which I take as an example, that is in the supplemental bundle at 2280.
Do you want me to turn it up?
Yes, please. Just
page what? 2280.
2280.
Give me a second.
So this is the spreadsheet that I was asking him a number of questions on during cross-examination.
Yeah.
And I was asking about the revenue line. So if you look at KSA, the first big table about halfway down the page, there's number of applications, revenue per application, and total revenue. And that total revenue line, so for the first column of figures, financial year 2018, the 1.6 million, that comes from the claimant's profit and loss statement. So if you look at note 5, for columns A to F, I use actual data from the P&L. In the but-for scenario, I calculate the total revenue by multiplying the number of applications by the revenue per application. And that document that he's used is supplemental bundle 2298. Which is his workings on a profit and loss document that was sent to him by his clients. And one sees that he's included other entities. If one goes to supplemental bundle 2318.
2318.
2318. He's here summarizing the post-termination revenue per entity. And for each one, he identifies a different entity. So KSA is KSA entity, Iran, Spain entity, Lebanon, Spain entity, Ghana entity. So he's not restricted himself to the claimant's losses. And that requires an explanation of what's the basis, either in accounting terms or in law, for that treatment. In relation to parts of his evidence, I simply identify the following on which I rely. In the course of his cross-examination, I asked him about whether he had included other entities in his calculations. That's day 8, pages 17 to 18. He confirmed that for KSA, he had included High Skies. That's day 8, page 70. And for Iran, he'd included, for example, dividends paid to the individual Mr. Kamuni and Mr. McCall. That's day 8, page 72. And he had aggregated those even to the figures shown in the usury accounts. Usury is the accounting firm for C1's accounts. That's day 8, page 69. In the course of that evidence, he agreed, as he had to, that these are not subsidiaries. That's day 8, pages 19 to 20. And it's important then to look at his justification for doing that. The first place in which he gives a justification is at day 8, page 19. And the question that I asked him is, so breaking that down, it follows from your answer that you've not taken into account just the claimant's profits. You've included profits from other entities in each jurisdiction, haven't you? His answer, the profit that was realized in other jurisdictions was the claimant's. Access Group actually billed these entities, so all the profit was actually transferred. So he's saying that there was a billing entitlement and that it was actually transferred. That suggests strongly that he was looking for a contractual entitlement of some sort, which was the basis on which he included them. He repeated that day 8 on page 22, in which he said between lines 3 to 6, as I mentioned earlier, the profit, the claimant's Access Group, has billed these companies a certain amount, so the profit is actually transferred and was deposited in an Access Group. So again, reference to some sort of contractual entitlement to issue a bill. The contracts on which he's relied, there was a fundamental misunderstanding in his evidence as to what they did. The first of those contracts is Supplemental Bundle 1279. My own friend took you to this. You may recall it. This is the commercial contract between Skyworld and Access. It is in my submission unambiguous at page 1280. In the consideration part, the second party will remunerate the first party. That is to say, Skyworld will remunerate Access against fees and charges specified in the commercial appendix. That commercial appendix is at page 1286. And the relevant part of that is at 1288. Clause 13 of which says, Skyworld should settle all Access Group invoices within 30 days from invoice, as per a separate commercial and detailed service level agreement, for 1% of the revenue for the exclusivity within Saudi Arabia. So that was the complete entitlement under these contracts of the claimant company from Skyworld. That was the same under the vis-a-vis contract, which is of the same territory, but for an earlier period. That's a Supplemental Bundle 1290. And Mr. McCall's clear evidence was that these were not a sham. They had legal effect. And you're right, the evidence for that.
What was that last page reference?
The vis-a-vis contract is 1290. You're not just taking Rhonda to the oral evidence. Mr. McCall's evidence, I invite Rhonda to look at day 3, page 186 down to 189, in which he says this was not a sham. It wasn't intended to disguise the situation, from which it follows that this was the legal arrangement between the companies. I also asked him why they hadn't been produced for the other territories. We haven't seen them. They've not been disclosed in respect of Ghana and Iran. But Mr. McCall accepted that those would have existed, and although he declined to answer whether they're in the same terms, I invite Your Honour to infer from his lack of answer they were. Your Honour, finally, Mr. Girard's basis for including those revenues was wrong. I asked him about that in his cross-examination, day 8, pages 74 through to 81. What he did in that exercise is that he assumed on his client's instructions that these contracts simply weren't being applied. But that's not an answer, given the assumption that he's made that there was an entitlement to be billed from one company to another. If that's what he's looking for, a contractual relationship, then the documents I've taken on to are those that govern the entitlements of the claimants. And in
just flesh it out for me slightly more. The basic position is what?
So the basic position, this is a claim that's brought by the claimants in respect of their losses. Now, they can establish that in my submission in one of two ways. Either the corporate structure was such that they were going to receive these monies by way of income. Now, the only obvious way in which that would happen is if they were wholly owned subsidiaries who were declaring dividends up to their group company, which was the claimants. Now, that wasn't happening here because the shareholders of each of the entities weren't the claimants, but were Mr. McCall and Mr. Kamuni. So that's not the basis on which Mr. Girard was relying. What he was relying on is there was an entitlement to bill. Now, that is a contractual explanation and depends on the contracts that I've taken Your Honour to. In his report, it's obvious that he had misunderstood what those contracts said because he was proceeding on his client's instructions. And the bit that I was taking Your Honour to, that bit of the cross-examination on day 8 between pages 74 to 81 is going through those bits of his report where what he's relying on. He says it's Mr. McCall's witness statement. And then he says, I have also seen these contracts, but I haven't mentioned them anywhere in my report. So, Your Honour, that's a key flaw to his analysis, and properly applied, it would have the effect that.
Sorry, I'm being very slow at the moment. Take the high sky situation. According to your analysis, what happens there?
The turnover, the revenue that Mr. Girard has identified reduces to 1%.
Go more simply. Forget about Mr. Girard for a moment. What happened on the ground?
High Skies incurs all of the expenditure.
Yeah.
So
as subcontractor. As
subcontractor.
Yeah.
And it has an entitlement or has an obligation to pay to the claimants 1% of the revenue that it earns.
Yeah. So what does Mr. Girard say about that?
He relied on the wrong contract. He relied on Mr. McCall's evidence that that's not the effect of these contracts. So I'll take you to the document, but it's in the passage of cross-examination I've just identified. I think it's page 1150 of the bundle.
Of the
trial bundle.
1150.
So paragraph 1.3.19.
Hold on.
Sorry.
Yeah.
So 1.3.19, he starts his evaluation of this. At this stage, it's the subcontract, so the relationship between the claimants and the defendants. And he says, under the Spanish and Cyprus contracts, the claimants collect all the revenue, and they then pay BLS a share of this revenue on the following basis. So far, so good. He then goes on to consider what the entitlement is between the claimants and the entities, which is at page 1159.
Yeah.
And in relation to the top of the page at 3.2.7, KSA's operations are conducted through a partner, High Skies. Access Group is paying the nominee shareholder a nominal fee annually for managing the day-to-day activity of the business, including operations, accounting, and HR functions. So that reverses the effect of the contract that I've taken your honour to. It's not Access who's paying a nominal fee, it's Access who's receiving a nominal fee. And the reason he's come to that conclusion, if one looks at footnote 45 to which he's referring, is that he simply relied on Mr. McCarthy's witness statement.
Which you say is contradicted by the document.
Exactly, by the two contracts.
Yeah.
And it was that I was putting to him in his cross-examination in those pages I was just referring your honour to.
Yeah.
And challenging him on why he'd use these, and ultimately he gives no explanation at that stage. It is a remarkable feature of this report that nowhere in it at all are those two contracts referred to, even though he says he had seen them. So he doesn't explain them away. He doesn't say why, on an accounting perspective, one gives them a different treatment. And on his oral evidence, that it is the entitlement to bill that creates revenue, his assumption is simply wrong. He has misconstrued those contracts or blindly followed Mr. McCar's evidence. And if they're properly construed, then the only entitlement is to 1% of that revenue that he's identified.
Yeah.
I'm conscious of the time, so I'll simply, the last bit is simply the second error with Mr. Girard's reasoning is the materials on which he has relied. So for the purpose of this 9-month period before termination from which he derives the claimant's revenue, he's essentially relied on 4 documents. One is the profit and loss document that his client gave him. 2 is a trial balance document, which is simply an extract from the claimant's financial Sage accounts or whatever the software they use. The 3rd is the ProX accounts that were produced by the auditor, Mr. Casas. The 4th is the Access accounts that were produced over various years by Mr. Ussery. In my submission, the first 2 of those don't deal with the issue that has arisen in this case. They are documents produced by the claimants, but don't identify the entitlement to that revenue. They identify what was earned under the contracts, which is a different thing. The question is, are these the claimant's losses as opposed to High Skies, any other entity, and are they the claimant's expenditures? So the corroboration that Mr. Girard was doing of comparing those various documents and seeing what the revenue position was doesn't engage with the issue that has arisen between the experts, which is who is entitled to these monies. In respect of the remaining 2 documents, the ProX accounts and the Access accounts, they were both documents produced for the purpose of this litigation. Mr. Girard says that in terms, and in those circumstances, they are expert evidence. They're expert evidence for which no permission has been granted. And by relying on those, Mr. Girard is simply abdicating his responsibility to identify the question of what revenue was properly earned. And so, Your Honour, the bits of the evidence on which I rely for that, the first is the accounts themselves at page 1337. This is the ProX accounts. Oh, sorry, it might be supplemental. No.
You carry on, I'm listening.
Sorry, it's 1337, which is in the experts' appendices. And that is a ProX account that contains the expert's declaration. I asked Mr. Girard whether it was, notwithstanding the auditor's opinion, which is in the first 2 paragraphs, which said that it was all compliant with IFRS and that all of the financial statements had been audited, it was still safe to use these documents in order to extract the figures that he had used for the 9-month period in the year ending December 2023. His evidence of that was in the transcripts, day 8, pages 50 through to 55. And in respect to that, I asked him, does the email that Mr. Cass has subsequently produced remedy all the errors in those accounts? I asked him, so in your professional opinion, is it safe to use those ProEx data in respect of 2023? His answer is yes. But that in my submission requires this court to have a degree of caution in relying on his evidence. Plainly, that email does no such thing. And what was necessary was the documents that Mr. Thomas says that he needed, financial statements, tax accounts that would corroborate the revenue that's paid by particular entities, primary documents that show what the entitlement was as between the claimants on the one hand and the entities in each jurisdiction. Now, the claimants could have done that in a number of ways. Bank statements, tax returns, could have done it by showing invoices that are raised between the claimants and the entities. None of that has been produced. We specifically asked in our requests for those documents to be produced and went further and gave a warning that the claimants weren't proving their case. The same in respect of the access accounts. I asked Mr. Girard in respect of those on day 8, between pages 62 to 67. And I asked him, in light of the fact that those weren't produced in accordance with the regulations under the DWC regulations, Dubai World Centre, I asked him, would it be necessary then to look at the primary records in order to verify what was in those accounts? He said no. He said, when I'm performing assessment of damages, I'm not going to re-perform a full audit. I asked him, but it depends on the nature of the exercise you're undertaking. If there's any doubt about the financial statements, presumably your inquiry would go a little further. You would look at the primary documents, wouldn't you? He said, I didn't have any doubts about the financial account. Again, that given the specific issue that is arising in this case, which is the entitlement of the particular entity and the evidence of revenue, was not an appropriate answer, because he has simply left it to the accountants who aren't appointed in this litigation, who can't be examined, in order to give an answer. He's taken it at face value. And that answer at face value is contradicted by the 2 contracts to which I've taken your honour. So there is a glaring error on the face of the contractual documentation as to whether or not the revenue was what both of those professionally prepared accounts suggest they were. For those reasons, in my submission, the claimants don't establish that there is a loss of any more than a nominal value. May I simply take your honour to our request to produce the documents that we say are missing? Supplemental bundle.
I'm sorry, I don't mean to interrupt. I just want to check that there will be enough time for my reply. Mr. Owen's gone a reasonable amount over. I'm obviously happy for him to do so, but I just want to check that's not going to impact on my ability to.
I thought it's been an hour, 2 hours and a quarter so far.
Yeah, I thought I had another 10 minutes, but if not.
I thought he had 2.5 hours.
No, he has 2.5 hours, including a 15-minute break. By my calculation, I think he's been 2.5 already.
We can give you. He's been 2.25 already.
I'll bring it to an end now. Anyway, I'm coming to.
So I'm not trying. I'm very happy for him to talk as long as he wants. I just wanted to check that it's not going to.
You only want half an hour, but Mr. Freeman, is that right?
Yes.
Yeah, that's fine.
Okay, I'm grateful. Because I'm not trying to shorten him. He's He's happy to talk as long as he likes, as long as it doesn't impact my ability to reply. That's all.
Yeah.
I mean, I should speed up. So I will finish. I was coming to the end anyway. I was simply drawing your honour's attention to the request that we had made for these documents to be provided. So this isn't an artificial dispute that's been created at trial. It has been a steady request that we've been making to see these primary documents. Supplemental bundle 1596. And the request, the items that we were asking for, item 21, 24, and 25, which were the primary documents that Mr. Thomas said was necessary.
Mm.
I'm going to bring that up. So item 21, we asked a monthly bank statement showing the deposits related to the revenue from the Spanish and Cyprus contracts to confirm the actual receipt of claimed revenues for the periods. Claimants objected that request for lack of sufficiency, relevance and materiality. Now, plainly, in light of where we are, that was wrong. Item 24, we asked for copies of tax return, VAT return, Zakat, WHT returns and other compliances with other compliance returns filed with the relevant authorities. Same response. And then item 25, historical revenue data and accounting records from local entities in KSA, Iran and Ghana for the Spanish and Cyprus contracts for the period 2016 to 2023. And again, we received the same response. So this is an exercise that we've been asking for some time. And indeed, at 5265 of the bundle,
Main bundle.
Main bundle,
Yeah.
we wrote on the 6th of March 2025, so after those requests produced were made, in respect of the evidence for the experts. And the relevant bit over the page at 5266, we refer to the expert evidence, and 4 paragraphs down, the first 2 matters that we have identified. This was about not having an initial meeting for the experts. The first 2 matters that we've identified carry the real risk that the experts' reports will be less helpful to the court because the issues will not have been discussed and identified before those reports are produced. Moreover, as we previously indicated, and as was raised at the case management conference, your client's pleading of a loss is currently deficient in a way that is not being cured by your client's disclosure. It's impossible to know from it what losses are claimed, how they've been computed, or what revenue and expenses have been taken into account in computing them. It was for those reasons that we've identified a specific list of issues and an early meeting of the experts. And then continuing down, 2 paragraphs below. That said, we do not consider those points in themselves justify a hearing, although we reserve our client's rights, including as to the need for any consequential directions in the future. Additionally, we remain concerned that your client has not provided any substantive financial documents to support its claims. That, however, is principally a matter for your clients who need to prove their case and who do not currently appear to be doing so. So we squarely raised this, not only in our request, but subsequently. And if the position is now that the case isn't proved, it's not for lack of trying on the defendant's part. Your Honor, that leads me to the general relief. In my submission, on the evidence, the counterclaim for the outstanding debt due stands. I accept that the overcharge is not something that the defendant is entitled to. The defendant asked for a declaration that each of the subcontracts has been terminated, and that in my submission.
Sorry, on the overcharge, therefore the claimant succeed on that.
Yes.
Yeah.
The starting point in relation to Mr. Girard's analysis in my submission would be to start with his scenario 2.3. The scenario is a little convoluted, but 2.3 is the contract was validly terminated in October 2023, but there's a potential non-compete covenant. The others all assume a long-term obligation that didn't exist, extending up to the end of the second Spanish main contract, so going up to the end of March 2028. So scenario 2.3 is therefore the correct analysis. That was a document that took Your Honour to earlier. Unless I can assist, those are my submissions.
No, thank you very much. That's very helpful. Mr. Friedman, should we take a quarter of an hour, then you can have your half hour?
Yes.
Right? We'll break for, according to my watch, it's 25 past. So we'll break till 20.
But oh, sorry, I think you've muted yourself. I don't know if perhaps at the end I thought you were still speaking.
Can you hear me now?
Yes.
Right. I was just saying it's just before 25 past on my watch. So in 16 minutes, we'll resume at 22 by my watch.
Thank you.
Thank you very much. Yes, Mr. Friedman.
Yes, thank you, Your Excellency. So I want to start with the series of points that Malofra made first, which is in relation to his suggestion that now this is a contract that the contract that was ongoing expires on a day-by-day basis, and he was forced to try to raise this new argument because of the point that I made in both opening and again in closing, that the problem with the way in which his case goes is that his pleaded case is that the contract, which he says was renewed, is terminable at will, and therefore that brings one squarely into Article 272 territory. And he's
Mr. Friedman.
Yes.
The case he is advancing is there in his pleadings. Paragraph 48, I think it is, or 42.
Let me just get that up.
And he showed it to me at the beginning of the trial. Sorry to interrupt you, but
well, I'm just looking at trying to look at the paragraph. Yes. So paragraph 42. I mean, my submission of the case is clearly not there. He says, paragraph 42, page 135, the party's conduct gave rise to a new contract in respect of each visa centre operated by the claimants, made or demonstrated by their conduct. Fine. By that contract, the parties agreed to perform the services and obligations as they had previously done under the Spanish contracts without any fixed term. So I'm right about saying he says there's no fixed term, but at the will of the other. Or alternatively, or on terms to be implied that either could give reasonable notice to determine the contract without cause.
Yeah.
So that is saying that it is at the will of the other. And if we pick this up, 165, where he further explains this. Give me one moment. Yeah, so it's at paragraph 6. Page 165, the new Spanish contracts contain no fixed term and were terminable at will or by giving reasonable notice. So that's his case. The case that he adopted in his closing was to try to suggest that this was a contract that simply expired on effectively it would have to be that it expired each day. And that's not what his case is. And we can see this. It follows at paragraph 7. The defendant properly and lawfully terminated those contracts because the claimants failed to properly respond to a legal notice, paragraph 7. So I'm happy to be proved wrong, but in my submission, from my reading of his defence, nowhere does he say that these were contracts that on a day-to-day basis expired.
Right.
And that's the distinction that's the distinction that I'm highlighting, which is that's how he's put his case in a different way in closing, which is to try to suggest now that somehow he was saying that there were this was a contract that on each day just automatically came to an end. That is not what his case is. His case is that they were terminable at will, as it says there at paragraph 6, which is that they are terminable. Someone can choose to seek to bring it to an end. That is the opposite of a case where a contract automatically expires. This is, I should make clear, this is in relation to, if he's right that on the proper construction of the original contracts, this is talking about the new contracts that arise. I don't dissent that if I'm wrong on the construction of the first set of contracts, that those contracts would have expired if he's right on the first construction point. This is talking about the second, what he says, the contract that he says was in fact in place going up to October 2023.
Yeah.
And so that's why my submission, this premise that he's come up with now to try to get around this difficulty, that somehow these were expiring contracts on a day-to-day basis, doesn't work. And again, he specifically pleaded it's not got a fixed term, so he can't rely on the fixed term point either. But even if he had pleaded it, even if that were to be his case, it would be wrong. Now, my learned friend didn't engage whatsoever with the case that I relied on, which makes clear that the mere continuation of performance is enough. That is the case. I don't know if Your Excellency's had the opportunity to download that yet.
I haven't, but I will later.
Well, I do wish to emphasise it. I'll read it out again because it's just so, it's just a complete answer.
I remember it from your submissions, but
I'm grateful.
To read it again.
It's a complete answer. The third paragraph on page 1578. It's not necessary that it be often accepted as being a single instrument may be manifested by any conduct which leaves no doubt as to consent, equally inferred from reliance and performance thereof. And it's such an analogous case because my learned friend is suggesting that somehow if you just carry on performing a bit, well, then you're just taken as it being from day to day. In that case, there was a 2-year contract that expired, and the companies sent some legal work to the lawyer. And it was held in that case that therefore meant that the contract not just was ongoing, but was ongoing through another full fixed term. So it's very similar to the facts of this case, and it shows exactly what I'm saying. My learned friend is required to ignore what that case provides. So that's my second point on that. My third point on that, relatedly, is that my learned friend didn't accurately describe the points that I rely on in relation to the steps that are to be taken. And that were taken. The first point is it follows from that previous case. He suggested that I only relied on matters in relation to the national visa. I do rely on the matters in relation to the national visa, but I rely on the full sweep of continuing performance set out at paragraph 9 of my closing note. The national visa is one of those, and it's a very important example. Because it particularly illustrates the point, because it is in fact dealing with a new requirement under the Spain BLS contract, but it wouldn't make any difference even if it weren't. But he was also wrong. He took you to one email chain and said that was the high point of my case. That was the email chain leading to trial bundle 3461, and said that was all I had. Well, that is just wrong. I've set them out at paragraph 9 of my skeleton argument. But for example, he referred to the email chain at trial bundle 3450 and said that there was no BLS involvement in that. In fact, and I've set this out in my closing note, there's repeated reference to what head office wants. And Mr. Sahu accepted that was a reference to BLS. So that shows that that's what BLS wants. My learned friend also failed to deal with the email chain at 3426, which goes on for 16 pages, all of which involves BLS personnel and which is about the implementation of the national visa. He also failed to deal with the email chain at supplementary bundle 302 to 308. That, again, is an email chain that directly involves BLS personnel and is about requiring us to implement matters under the national visa. So the attempt to downplay all of the events was, in my submission, not an accurate one. Fourth point in relation to that, my letter just simply didn't engage with paragraph 7 of my closing, which I dealt with. And that makes absolutely clear that it was agreed between the parties. Both parties proceeded on the basis that the same termination provisions applied. That was accepted by Malern's witnesses, and that is an inconvenient point for him, but he had no answer to it. He then, fifth point on this, he tried to start from what I would say is a false starting point, where he said, effectively, well, everyone accepted that there needed to be a new contract negotiated. But that's just not right. I've dealt with that at paragraph 8 of my closing. The point was that there was an agreement between an acceptance between both sides that there would be a commercial renegotiation. That was a commercial renegotiation that the Agarwals tried to open in 2022, which demonstrates that it was nothing to do with the new contract. It was just that, as and I've set out all the references, and as Mr. Sahu accepted, BLS, when things were going better, just wanted to come back and get more money. And my client was happy to, in good faith, agree to give them more money. So it was a fair position. My late friend referred to various statements from Mr. Kamuni in evidence. I do say they didn't give a full picture. So just running through them, for example, paragraph, he referred to page 73 of day 3. He said, well, I'm open to renegotiate on the commercials. And then he explains the point at page 110 of day 3. And this is the second email, the email that responds to the 3rd of July email, the response that comes back from BLS, which starts talking about removing my clients as a partner. And Mr. Kamuni said, when Jitendra responded to me, it triggered. It kind of freaked us out internally, because here we're not talking commercial, we are talking change of partner. And again, page 81 of day 3, he said, you have to understand the frame of mind. BLS won the contract, won the tender. That's the news I got in November 22. So, okay, great news. As per our contract, we're continuing. And my learned friend took you to the document at 3062 of the trial bundle. That, again, in that document, Mr. Kamuni says that the commercials can't be negotiated until the future timeline is clear. So there is nothing in this to suggest it was anything else apart from a renegotiation of commercials, which have been started under the old BLS Spain contract and was repeated on numerous occasions over the years. And I've set that out in paragraph 8 of my closing note. But when my learned friend sought to suggest that the starting point was that the parties agreed they needed to negotiate a new contract, that was just simply not borne out by the evidence. That was just wishful thinking. So that deals with the predominant part of that. My learned friend, just to define. Sorry,
can you help me?
Of course.
You draw a distinction, very clearly draw a distinction between the change of the commercials and renegotiation of other aspects of the contract. Where is the line drawn?
Well, I don't draw a distinction between renegotiation of other aspects of the contract in that sense. I draw a distinction between, are we as partners in good faith negotiating amendments to the contract, which is what they were required to do as a matter of UAE law, versus are we going to remove you are we just going to rip up the contract? One is about good faith negotiation on an ongoing basis. So in 2018 that happened. In 2022 there were discussions about this happening. Neither occasion was it suggested, and Mr. Sahu that it was accepted that it wasn't suggested, that they were going to remove my client. There was no entitlement to do so. Similarly in 2023. So the difference is between a discussion which is about changing the parties sitting down, parties who are subject to a duty of good faith, sitting down and working together to make it to come to an amendment to their agreement, versus just saying, well, there's no contract between us. There's a fundamental distinction.
Okay, thank you.
But as I say, on any view, you know, even if that had been the starting point, given all of the conduct that we saw, and in light of the case law that I've gone to, it's quite clear that, you know, my client was required to and did undertake significant investment and work, recruitment of staff, all of these steps. That is just fundamentally inconsistent with the idea that Diwakar Agarwal could have called my client at 5 p.m. and said, sorry, you're out from midnight, or could have called him at 11:59 p.m. and said, sorry, you're out. And it's just, that is in my submission a completely unreal suggestion. Malenford spent some time going through various authorities on contracts just expiring. We're not in that territory for all the reasons I've given, but in any event, those authorities really just didn't support the point that he was making. You'll have the references, and I can go back to all of them if it would assist. But I think given the time, I could just sort of make the points. He referred to authorities bundle 1467 and said it was by way of analogy. If one actually looked at what was being referred to there, this was in the context of contracts that were conditional or where there had been a defect, fraud, mistake, or cheating. So they just have nothing to do with the current situation. He referred to a Mukawala contract, which is just a different type of contract, and it's not suggested by my lead friend that this is such a type of contract. So, I mean, it would be like me referring to a specific insurance contract, for example, that it's just a different context. And then he referred in a couple of places, pages 75, pages 61 and 62, to the idea of execution by performance. But the only example given of execution by performance in those authorities is where you have a sale contract where the goods have actually transferred. So I buy a packet of fish from you and you give me the fish, and I've given you the money, and therefore the contract comes to an end. And similarly, it was said in relation to a lease that ended at the end of the fixed period of the lease. So that's nothing to the point in relation to contracts which are the ongoing provision of services. So they just don't have any relevance here. But as I say, we're not really down that road, not only because it's not a pleaded case, that's not my learned friend's case, but it's also not fundamentally what happened, what the evidence shows, including my learned friend's own evidence. Now, in terms of moving on to Article 271 versus 272, as in which one are we in? My learned friend sought to respond on that. He ignored the fact that there is a distinction between notice and termination, as drawn out in Al Sanhuri, and there's a need to deal with both, and that if the contractual word is dealing with anything, it's dealing with notice. And obviously, not only does there have to be an express resolutory condition, but it needs to be an express resolutory condition as to termination. And Malefred also didn't deal with the examples in Al Sanhuri, where the wording was, in my submission, far clearer than the wording we have in this case, but it still was within Article 272, not within Article 271. Now, he took you to, if we may just get this up, the authorities bundle 620. And this was the...
Say again, what page?
620. This was the DIFC and ZIA case.
Give me a second.
Sorry.
Yeah.
Now, I mean, obviously, I would say that this doesn't take us very far, in the sense that this was, as my little friend fairly accepted, obiter. There was no, given that there was no consideration of the principles, no reference to al-Sanhuri or equivalent sources, and it's obviously talking about a differently worded clause. But in fact, if one looks at this clause, one can see an important distinction between this clause and the clause that we have in the present case. Your Excellency will, I'm sure, remember from my submissions earlier, where I said that one of the important aspects was saying when, and sorry, I should just be clear. As I made clear earlier, I accept that it is in theory possible that there could be an express resolutory condition that doesn't, in fact, say it can be done without a court order, but that will be a rare case, and this is wording that is available to the parties, and they've chosen not to use it. But I also explained one of the relevant considerations is whether the nature of the clause leaves over matters of judicial consideration, of judicial discretion, and that's an important factor in suggesting that it's not an express resolutory condition. And I gave the example earlier of, well, contract terminates without the need to go to court if a formal insolvency process is entered into. And this is an example. If one looks at the clause, it says in the event that the buyer fails to pay the payments as agreed date in clause 3, or fails to complete the transfer on the agreed date. So the factual scenario in that case, and I wouldn't necessarily accept that this obiter description is right in saying that this is within 271, but assuming it is, regardless, that this distinction is important, that the only consideration there is was the money transferred or not, and that is a simple matter of pure fact. Either the payment was made or it wasn't, and so there's not a judicial discretion there. There's not a judicial consideration. All that's happening is, well, was the payment made or not? If it was, no termination. If it wasn't, termination. So that clause is an example of what I described earlier, which is where you could have something where there's effectively no discretion for the court, no discretion at all, and that would be an example of one of the very rare cases. Now, in our case, of course, it's completely different, because it's saying, is there a material breach? So not only does the court need to consider the question of whether there is a breach, but the court also needs to consider the evaluative question of whether that breach is material. And so that's, again, a strong pointer that this is a matter for the court. And as I say, the starting point here is we don't have the express wording. It isn't ipso facto. So that's what I wanted to say on Article 271 and Article 272. My learned friend dealt with the point about whether there was an entitlement to suspend. And his basic point was there needs to be mutuality. He took Your Excellency to an authority at page 159 of the authorities bundle. I don't think that didn't say anything else apart from it's a matter of fact for the court to consider. But it's important to bear in mind that there is mutuality in this case. Number of reasons why there wasn't compliance with obligations. So we, for example, in response to the 19th of September legal notice, we wrote back and said, you're not entitled to the overcharge. Please provide us with an invoice, a corrected invoice, so as to make payment under that corrected invoice. It's now accepted by BLS that they were wrong to seek the overcharge. But they refused to provide the corrected invoice. So that was their obligation. And as Mr. Gupta explained, the provision of the final invoice was required for payment to be made, and that was the basis on which the parties operated. So we simply went back to them, correctly pointing out that the invoices were too high and saying, give us the corrected invoice, please. And they refused to do so. So that's a clear case of mutuality. The same point in relation to interest. I don't think my learned friend dissents, or didn't mention it if he did, from the point that they weren't entitled to 18% interest. But we were being told that the only way we could discharge was based on 18% interest. And again, we went back to them and said, you can't charge us this interest. And again, they refused to do that. So there's an obvious mutuality. But it also goes further than that. There were mutual obligations under the contract. I took Your Excellency to them, including the obligations in relation to the website. It's now accepted, although the full extent of it isn't accepted. It is now accepted. It was accepted in Ms. Curian's evidence that BLS was deliberately denying us full use of the website and the technology. We were blocked from having staff members even be able to use the system at all. We were blocked from having the appointments that were necessary for the second half of October on the website. All of the other points, which I do submit on the evidence, were all part of a deliberate blocking of us. But in any event, there was a blocking, even if it wasn't deliberate. All of that stopped us performing our obligations, and there's a clear mutuality in that. There's also mutuality because the parties are required to act in good faith towards each other. Now, I won't go over the facts on that, but we say there was clear bad faith acting. And Mr. Kamuni was absolutely clear in his evidence that he said to BLS that it's because you are acting in this manner, this inappropriate manner, that I'm temporarily withholding this payment. And so it's a mutuality there because we were entitled to good faith performance from BLS. And then BLS in response could expect good faith performance from us. So that is one leading to the other. So this is a clear case of mutuality. And it simply goes to this fact that otherwise what would happen would be that we would be obliged to make payments of sums in circumstances where where it was made clear and we knew that we were going to suffer damage from BLS's actions. And so it cannot possibly be correct that we were required to pay in those circumstances. So on that, I say that we can rely on mutuality. Now, my learned friend then dealt with late payment, and he seeks to dress this breach up as a late payment. As I set out in my closing note, the only point that he took about late payment was from the invoices from the middle of June onwards on the case in the defence. But in the first place, there wasn't persistent late payment because, as we can see from my rework schedule, in a number of instances, payments were early. So it wasn't persistent late payment. And in other cases, it was in, as Mr. Gupta put it, approximately 30 days. Now, there is this point that I accept that there's this point that relates to the invoices on the 15th of July, 15th of June, 15th of July, i.e. are the middle of the invoices at the middle of the month paid only at the end or not. But even if I were wrong about that, it would show that there's not persistent late payment, because if I'm wrong about that, I accept my table needs to be rejigged a bit for those middle of the month invoices. But it doesn't affect the entries for the end of month invoices, and those were being paid early or on time. So there wasn't persistent late payment either. But I do take issue with my learned friend seeking to describe the breach as being that. I went through all the facts in my first round of my closing submissions. I'm not going to go back to them, but the position was, contrary to what my learned friend says, as Mr. Anand accepted, there was no issue at the time of the September 2022 discussion, apart from the use of 60 days as opposed to 30 days. And the document and Mr. Anand confirmed that in fact payments were being made on time otherwise. So there was no issue with it. Otherwise, there was just the usual back and forth between partners, no real chasing, no notice given, no genuine issue at all. But I do take issue with his suggestion that this was a late payment, and that's what the breach is. The reason for that is that any payment that is not made is by definition a late payment. So it proves far too much. If my learned friend were right, then if you have a contract where you have a cure provision and I am required to pay by midnight and I pay by a minute past midnight, then that's late payment. And then the answer to that would be, well, sorry, you can't cure because it's a late payment breach rather than a non-payment breach. So in my submission, there can't be a non-payment that isn't a late payment. So it just doesn't work for my learned friend to try to re-describe it in that manner, because and it proves too much.
Well,
now then, sorry,
just so you can answer this. I take your point. Every non-payment is a late payment. Immediately, it's not paid. But by late payment, people generally would mean systematic late payment, continuous, repeated late payment. What do you say about that?
Yes, well, in terms of my learned friend's pleading on that, he relies on the payments that were from the 15th of June invoices onwards. Now, I accept that some weren't paid. On our description, they were paid in approximately 30 days, but they also came on the back of other invoices and around the same time of those invoices being paid early. So there's not systematic persistent late payment. And in any event, that's just, he focuses on a handful of invoices for each contract and tries to paint this as persistency. And in fact, the evidence from Mr. Anand was that there wasn't persistent late payment. So in my submission, he just doesn't get there on the facts. And in any event, the answer to saying you have a problem with late payment is that you be given an opportunity to cure it, and it's obviously curable because you then start paying on time. So that's the answer to that in my submission, which is it's a curable breach, if it be a breach. There's also an important and related point in relation to materiality, and I haven't put it in the bundle, except there's an English case. It's obviously a different system of law called Valilas, VALILAS, and
it's in the bundle, is it?
It's not, no. But I just wanted to. I mean, I can make the point from it. Valilas and Valdet, VALDET, where it was found that in that case, that where a late payments, it wasn't a repudiatory breach. And the point that was made by the Court of Appeal there, Lady Justice Arden, but it's a point of general obviousness really, is that when you look at materiality for a late breach, the materiality is, well, how material is it that you get your money a bit later? It's about the impact of receiving, specifically, of receiving the money a bit later. And in the context of a listed company of this sort, in the context of the overall amounts, and in the context of the really very limited time that they would have to wait for their money, on any view, this isn't material. Put to one side the amounts, but as I say, I do rely on the amounts. But if you put that one to one side, it's not about the absolute amounts. It's about just the mere delay and whether the downside from that delay is truly material in the context of these contracts. And these are contracts where multi-million-dollar operations are being affected. It's in the course of 8 years of payments. It's in the context of the entire relationship, the complexity, all of the aspects that go into this. And what is really being said, would have to be said, is that receiving payment a few days late, even if it is a couple of weeks late, month late, is material to the overall contract. And so in my submission, that's another point that just shows why this just doesn't get there.
Would you kindly send a copy of Varalas to my clerk?
Yes, absolutely. I'll send it, of course, to Mr. Oram. And there's a dissenting judgment of, I believe it's Lord Justice Underhill. It's a short judgment from Lady Justice Arden, paragraph 58.
Yeah, thank you.
Thank you. So that then brings me to the non-compete. I mean, my Lord didn't really have anything to say on the non-compete. He didn't come back on the fact of competition as between any of the contracts, and he rather invited Your Excellency to start your consideration looking at on his case, it would be where you just implement the non-compete from October 2023 for 2 years. There isn't an answer on non-compete. The only thing he said about it was the survivorship point. Now, I took the court to a case that deals with that in my prior submissions. Well, if it didn't come back, I don't deal with that further. But it's also just perfectly obvious from reading the clause and the survivorship clause that it does survive. And there really is no answer to that. Now, just one point to bring up, because my level obviously talked about quantum, but it's just to emphasise that there's a slightly different point about quantum. The approximation is 2 years of profits. Now, I'm going to come to why there's nothing in my learned friend's points about high skies and so on in a moment, but it's just to emphasise that the sum sought is the sum that would have been obtained in a negotiation between the parties, and there's not been any comeback on that. Mr. Kamuni was asked about that in cross-examination. He reiterated this at page 65 of day 3. He explained he would in good faith have agreed to sit down and say he's not going to hold BLS to ransom, but he'd say, well, look, you have my non-compete, so you need to buy me out of that period. And so he would have agreed a sum of money reflecting that. And that's a factual matter as to what would have been negotiated. Now, Mr. Oram has diligently sought to try to create something from nothing about these high skies points. But on any view, when it came to the negotiation between my client and BLS, it would have been about the figures about what the operations were, in fact, leading to in terms of revenues. And so there's all of these points about high skies and so on just don't go anywhere on the non-compete, because this would have been Mr. Kamuni sat down in a room with Diwakar Agarwal or Shikhar Agarwal and knocking out a figure to reflect the 2-year non-compete. So that is the basis of the loss. And so all of these clever points, but wrong points that my learned friend makes, just don't come into it, because that wasn't what the discussion would have been, and Mr. Kamuni's evidence on that was unchallenged. So that then brings me then to quantum, and my learned friend, look, he had a good go at it. Are
you going to be very long?
No, I won't be very long, I hope.
We're stretching a bit your half hour.
I'm sorry. I've tried to be as efficient.
And carry on, quantum.
I'll be as quick as I can. But the starting point in this is my learned friend went into bills and obligations and so on. That is not the basis on which we seek payment. We seek payment as damages in lieu of specific performance to put or damages which put Access in the position that Access would have been, and therefore it's would Access have either received the money as a matter of fact, or indeed did it have the right to the money but has been giving it to someone else. But as a matter of fact, it is absolutely indisputable that Access has been receiving the money. Now, Mr. McCahal gave clear evidence on that. The only way that the court could reach the contrary conclusion would be to find that Mr. McCahill is lying about this. Now, my Lord Friend didn't invite Your Excellency to reach that conclusion, rightly so. Mr. McCahill and Mr. Kamuni were both helpful and honest witnesses, and that's not dissented from. And he gave clear evidence on this point, and so there is simply no way around that. That is, in my submission, the long and the short of this. Now, a long attempt was made to try to disparage Mr. Girard, who was a careful and considered expert witness. And my learned friend rightly didn't place any reliance on Mr. Thomas. There is no contrary reliable expert evidence before the court. So in my submission, it would be pretty extraordinary for the expert evidence to be disbelieved. Now, I took the court through it earlier. I gave the references to Mr. Girard's report, but he has traced through financial statements, and also, and this is the point my learned friend didn't come back on, and also the millions of dollars paid to BLS by Access. If my learned friend is right, and it's an absolutely absurd theory. It's an absurd theory that Access would take 1% of the revenues of the operations. Absolutely absurd. It doesn't stand up to a moment's thought on any sensible analysis. Mr. McCahill's evidence explains that that's not the case. But if that were right, how has Access paid BLS? That is the question that my learned friend had to engage with. For all the length of his submissions on quantum, he didn't do so. How did he try and deal with the second point, both of which is enough, but on the audited financial statements, he tried to say there were expert evidence. It's really not the correct characterization of them. These are audited financial statements. Imagine it were a UK company, and as happens, companies are sometimes late in submitting their audited accounts. During the course of the litigation, the auditor goes in, completes the audit, and provides the audited financial statements. That is what has happened in this case. And the suggestion that you couldn't rely on the audited financial statements would be frankly extraordinary. And so just because this is in relation to a UAE entity, it would be exactly the same. So the audited financial statements are reliable and can be relied on. And Mr. Girard is the quantum expert, and his view that relying on audited financial statements is appropriate is clearly right and should be given weight. So that's high skies. As I say, my friend elided the various points, but just to reiterate, Pro-X, there's no point in relation to this whatsoever. There is no local entity. My learned friend brought up the Pro-X audited financial statements there, based on the auditor providing a snapshot. But that's just a red herring, because for revenue, all of that is correlated by the DAR, as Mr. Gupta accepted. So I've dealt with that with KSA. For Lebanon, there's no issue at all. For Ghana and Iran, again, we have the audited financial statements, and then we have the point that about the monies being provided to Access through cash withdrawals. It's just to reiterate the point that it either could be provided to Access or it can be dispensed at Access's direction. And what my learned friend was left with was asking the court to draw an adverse inference. Well, the court has the evidence of Mr. McCahill that made the position plain that the monies all were Access's monies. And so, again, the court would have to disbelieve Mr. McCahill. Given the time, I won't go there, but just to add that there was eventually agreement reached on the documents that were to be provided to the experts. For example, supplemental bundle 5276. So, and no application was ever made. So it's a bit rich to suggest, to make the point about missing documents. But regardless, all of this has been considered by Mr. Girard. And so that's all I wanted to to say on loss, just doing that briefly. And then finally, just 2 points. On this, just on Mr. Tiara's point about monies not being paid in Saudi, my learned friend sought to suggest that Mr. Macahal accepted that this had in fact been going on. That was not correct. If in his witness statement at page 1012, he categorically denied this, and then at page 120, at page 41 of day 4, that was referred to by my learned friend. He didn't refer to pages 42 to 43. Mr. Macahal said his evidence was, well, if this did in fact happen, we knew nothing about it. He didn't accept that it happened. And then at pages 42 to 43, he explained why he thought it didn't happen. So this is just another completely unevidenced assertion. Finally, on bad faith, and I just want to, I'll just end on this. So my learned friend is sort of trying to isolate this. He referred to abuse of rights under Article 106 of the Civil Code, but there are 2 requirements that they had to meet: not to be in abuse of rights and to act in good faith. So there was an obligation to deal with us in good faith, an obligation to deal with the commercial terms in good faith. What we have is not just that. What we have is a situation where there was an orchestration of a termination. So everything was set up with a view to trying to bring this contract to an end. All of these actions were necessary steps towards, and then were part and parcel of the termination that in fact took place. It involved dishonesty, it involved keeping us in the dark, misleading us, misleading others, all the points I've set out. It involved the penal interest, it involved not recalculating the overcharges. All of this was part of it. Just to finish on in terms of competition, of course, we say that they were setting themselves up to compete with us afterwards, and that plainly is right. But we do say that they competed with us during the course of the agreements. I've already made the point about the breadth of the non-compete clause, and in this context, my learned friend accepted that from the 27th or 28th of September, they were in fact taking actions. So that was a breach of the non-compete. We still had a contract at that point. But in any event, we saw how they were blocking us from the system, refusing to introduce prepaid appointments, how we saw that there was a contract on the 21st of July in Lebanon, a contract on the 1st of September in Iran. And all of the elements that we saw, all of the activities taking place from April onwards, were all taking steps so as to interfere with our business. And so there clearly was a breach of the non-compete obligation happening from, I say from April 2023, but certainly for a very substantial period of time prior to the purported termination. It comes back to the fact that there was a need to terminate. That is why they sent the legal notice on the 19th of September. That's why they sent termination letters. There was a need to terminate, and that termination involved BLS acting in bad faith, both in that termination and in the whole run up to that as part and parcel of that. So that is, in my submission, therefore a complete answer to this, because they just weren't entitled to terminate on that basis too. So thanks for the indulgence of the time. I have tried to be as quick as possible. Those are my reply submissions.
Yes, thank you. Well, just one question to both of you. What do you want me to do about costs? I mean, in certain circumstances, it's obvious. Other circumstances, issues have arisen. Do you want me to reserve costs?
I would invite that, Your Honour, or allow a period for agreement if possible. If not, we'll deal with it in consequential matters on the papers.
Yes.
I'm just taking instructions. Yes, we're happy with costs reserved. It's also just to flag a point in terms of quantum. Obviously, if Your Excellency is with me, as I set out in my skeleton, depending on the precise permutations and formulations, it may be that it's something that we deal with in. It can either be taken from Mr. Girard's report or followed up. But I just thought I'd I'd mention that.
What you're suggesting, I might, on a certain basis, come back to parties saying, can you sort out quantum on this basis?
Well, my primary
Is that
position would be there's no need for that, because the figures in the lost periods we have specified are the correct ones. But it was just to note that if it is conceptually possible that Your Excellency would come up with, there are permutations that could end up with different lost periods, and it was just to mention that if that were to happen, I've set out in my skeleton argument how the figures can be extrapolated, or else I'm sure it's a point that could be agreed between the parties, or if not, dealt with briefly.
So you're leaving an option for me to come back to the parties and say, this is what I find on liability, and basically what I find on quantum, please supply the figures.
Yes, it would just be plugging it into the report, effectively.
Okay.
Yeah.
Well, I don't suppose there'll be any objection to me doing that if we get to this. Right. Well, thank you very much, both of you, for your helpful submissions. And sorry we didn't manage to finish on Friday, but things happen. And
Thank you, Your Honour.
Thank you very much indeed.
I can't guarantee when you'll get a judgment, but it will be as soon as I can. Thank you very much.
Thank you.
Thank you.